Good morning, members of the Uganda Law Society. Welcome to the CLE training on human rights law, this 11th day of December 2025. I'm honored to moderate this session. My name is Akot Jackie Abalo, and I'm an advocate of the High Court of Uganda. The conversation today couldn't have come at a better time. The training on the human rights law. Yesterday, 10th of December 2025, being the Human Rights Day. And secondly, noting the current political landscape of our country as we are fast approaching election periods. Yeah. Before we delve deep into the conversations, let us have a quick opening prayer. Can members online hear us? Just give us a thumbs up if you can hear us loud and clear. Okay, let's have a quick opening prayer. Melissa, can you take us through? Thank you.
Good morning, members. My name is Acheng Melissa. Let us humble ourselves for a word of prayer. Heavenly Father, in the mighty name of Jesus, we thank you for the gift of today. We thank you for the gift of life. Father, we come before you as a society of lawyers, Lord Father, who are going to sit and delve into matters concerning human rights, Lord. We pray that you may guide this discussion. May you be with us every step of the way, and may it be a fruitful discussion for each and every single person. Guide the moderators and bless them with a gift of wisdom and knowledge. In the mighty name of Jesus Christ, we've prayed. Amen.
Amen. Thank you very much, Melissa. I'm going to take us through a quick run of the program of the day. So we have just had an opening prayer, and we're going to have introductions very shortly. Thereafter, we're going to have remarks by the ULS Council member or their representative. From 9:15 to 9:45, we are going to have a session on understanding the right to political participation, conscience and association, limits and prospects from Ms. Pauline Nansamba. We're going to know more about the panelists later. We'll have a Q&A. Just a quick note to the members online, when the presenters come on to make their presentations, if you have any questions, please feel free to drop it in the comment sessions so that immediately after their presentation, they can address it. Yeah? We are good? Thereafter, we're going to have another presentation from Dr. Ernest Tashobia on exploring freedom of association and belief, and that is the faith-based policy. Thereafter, we'll have a Q&A session, and we'll move on to Mugabe Ivan Kaiti, Mr. Mugabe Ivan Kaiti, on the case for academic freedom in institutions of learning. Q&A will follow after, and we'll have another presentation, that is our final presentation from the day, from Dr. David Kabanda on exploring the right to food, the law, practice, and call for immediate action. Thereafter, we'll be ready to receive your questions. Yeah. Without further ado, let us have opening remarks from a representative from the Uganda Law Society Council.
Thank you so much, everyone. Thank you, our moderator, Ms. Jackie Akot, and thank you, our speaker that's here with us, Ms. Pauline Nansamba. We're happy to have you, and we thank you all for being here this morning. My name is Ruth Angom. I'm the program officer for professional development at the Uganda Law Society, and I've been delegated to give these remarks on behalf of our Vice President, Mr. Asimwe Anthony, who is away on other duties that are quite demanding. Yes, so without further ado, I'm going to read the remarks verbatim. Okay, our esteemed speakers. Yes. Our esteemed speakers, Ms. Pauline Nansamba, Dr. Ernest Katwesije, Mr. Ivan Mugabi, and Dr. David Kabanda, and our moderator, Ms. Jackie Akot Abalo, Senior Council President. Good morning. I bring you warm greetings from the Executive Council of the Radical New Bar. It is my pleasure to welcome you all to this human rights training held under the theme, Human Rights Are Everyday Essentials. This theme aligns with the International Human Rights Day commemorated yesterday, the 10th of December, 2025. Human rights are inherent to all of us by virtue of our humanity. It is therefore essential that we continually create spaces for dialogue and reflection. Today, we shall explore the freedom of participation, conscience, and association, examining their limits and prospects within the context of our current political landscape as we approach the election period in 2026. We will further reflect on freedom of association and belief, including faith-based policy, considerations, the imperative of academic freedom in institutions of higher learning, and the right to food and healthy living, with particular emphasis on the legal framework and the urgent call for action in securing this right. I encourage you all to pay close attention, engage actively, and ask questions as we navigate these critical discussions. I wish you all a fruitful and enriching engagement. Mr. Anthony Asimwe, the Vice President of the Uganda Law Society. Thank you.
Thank you very much. Ms. Ruth Angom, representing the Vice President of the Uganda Law Society. Members, as the theme for the Human Rights Day of 2025 states, human rights, our everyday essentials. Today we dive into the heart of a democratic engagement. Yeah? The rights that empower the citizens to shape their governance, participation, conscience, and association, limits and prospects. As we delve further into this conversation, we are going to be joined by our panelists, the experts on this, that is Ms. Pauline Nansamba. Ms. Pauline Nansamba is going to take us through understanding the right to political participation, conscience, and association, its limits and prospects. Members, Ms. Pauline Nansamba Mutumba is an advocate with 16 years of public service. She joined the service in 2009 as an officer and is currently the Director, Complaints, Investigations, and Legal Services at the Uganda Human Rights Commission. In this role, she supervises over 50 investigators and lawyers to deliver timely interventions and redress on a wide range of human rights issues. She also supports several administrative functions, including support to the Secretary of the Commission, Board of the Commission, and the procurement function. Ms. Nansamba's areas of practice over the years include human rights, litigation, legal advisory, employment, and administrative law. She's passionate about human rights, about the rights of women and girls, especially youth, social and economic and cultural rights. Previously, Ms. Nansamba worked with the Inspectorate of Governments before joining the Uganda Human Rights Commission. She also served as a part-time lecturer at the Uganda Christian University, where she taught negligence, strict liability, as well as international law, among others. In addition to a Bachelor's of Laws from Makerere University and a postgraduate diploma in legal practice, Ms. Pauline holds a Master's of Law in International Economic Law from the University of South Africa and a postgraduate diploma in Public Administration and Management from the Uganda Management Institute. She also runs a mentorship program for law students which provides the nexus between legal theory and practice and exposes students to the core values and soft skills required to excel in a fast-changing world of legal practice. Wow, what a bio. Members, join me in welcoming Ms. Pauline Nansamba to take us through this session. Please, let's clap online.
Thank you. Thank you very much, Jackie. Can I be heard? A thumbs up if I can be heard. I need to know I'm not talking to myself. We have 129 participants online. It's good to see.
On the floor. Listen carefully. If you have any questions, please feel free to drop them in the comment section so that she can be able to address it immediately. Thank you.
Thank you. Good to see you, Councillor Stephen. I saw you online and I was happy to see that some of my colleagues are online. A very good morning to you all. Greetings to my president and the vice president and council members, the CEO and Uganda Law Society generally. Thank you so much for this opportunity. I'm looking forward to having a very fruitful engagement. When I had the topic or the theme, human rights are everyday essentials, I was glad because that is how I perceive human rights, that these are basic everyday issues that we need to break down and help the regular person understand what we mean when we use some of these words. I'm privileged to be on this panel with my former colleague, Dr. Ernest Tashovia. It's good to see you here as well, speaking on the issue of freedom of belief. So just to delve straight into it, understanding the right to political participation, conscience and association, limits and prospects. As you said, Jackie, this cannot be more timely given the season that we are in right now, but also given that we have just commemorated the International Human Rights Day. It gives me great joy to speak into this issue. So when we speak about the right to political participation, freedom of conscience, and freedom of association, we can't speak about these outside of the framework of democracy, because it is through democratic processes that all of these rights that we're talking about are realized fully. And of course, we are aware that international human rights law treats these rights as essential for human dignity and vital in any system that claims to be accountable to its people. And I think I just want to start by highlighting that we cannot talk about it's not responding. Am I supposed to? Sorry, the technology is playing me a bit. Where is this supposed to point? Okay, so sorry about that. So as we were saying, this is our subject, understanding the right to political participation, conscience and association, limits and prospects. I've already been introduced by Jackie, and I'm really glad to have this opportunity to share. My presentation will cover these areas, understanding political and civic rights, particularly the right to political participation, the legal framework within which that operates, the interdependence and interplay of Article 29 of the Constitution, which is the one that domesticates that for us here in Uganda, the state duty to protect and promote, and then I'll speak into, that will be the more practical part. What are the limitations that we see, and what are the prospects and recommendations that we can have from where I stand? So I was speaking into the right to political participation as essential for human dignity and vital in any system that claims to be accountable to its people. And I think that is very critical. As states, that the duty to protect and promote human rights lies primarily with the state. And the framework that supports that is that as a state, we have chosen to be democratic. Through our constitution, and we'll look a bit into those, but through our constitution, we have chosen that we are a democratic state. Now, there are other forms of governance that we are all aware of, and so when we say that we choose democracy as a people, that is the consensus, that is the will of all of us as shared through the Constitution. And that is the premise. Outside of that, we cannot discuss these rights and responsibilities and freedoms. So internationally, we are aware of the International Covenant on Civil and Political Rights, and the fact that these rights are inherent entitlements and mechanisms through which citizens are able to influence public political life, express beliefs, and organize collectively in society. These rights are so much about our identity. As a human being, what do I believe? How do I express what I believe? How do I associate with people who may or may not share the same ideals or thoughts or views that I have? That in order to have an organized society that is progressive. So our constitution re-echoes these principles, placing participation and civic freedoms at the center of democracy. So understanding how these rights operate in practice requires both that we examine their normative foundations, but also the political conditions that have shaped their application over time. That is why oftentimes you'll hear people referencing the preamble to the Constitution. Because for us in Uganda, that is the basis. Recalling our history, recalling from independence, how have we developed, evolved as a society. And this constitution then guides how we perceive the right to political participation, how we protect those rights, and how we express them. The national objectives 2 and 29 provide a framework for these rights by providing that the state shall be based on democratic principles which empower and encourage active participation of all citizens. Active participation, all citizens at all levels. I hope as you're looking at these words, you're assessing how we are performing as a nation in implementing democratic principles. Can we say that there is active participation of all, at all levels, in their own governance, as well as the promotion of the rule of law? Article 38 of the Constitution provides for the right of every citizen to participate in the affairs of government, individually or through their representative, peacefully, and also through civic organizations. And this brings in the aspect of why the civic space is so important in democratic spaces. So when we're going to look at Article 29, which talks about these freedoms, the freedom of conscience, the freedom of expression, freedom of movement, freedom of religion, and assembly. But what I want to say is that there is an interrelatedness to these rights. But although there is an interrelatedness, we could also look at them individually. Although the rules of statutory interpretation guide us that since these rights are clustered together in Article 29, it follows that they are interrelated. But I want us to look at them distinctly so that we go into, we've said that these are everyday essentials. So I want us to look at them one by one, the ones that we're talking about today: political participation, freedom of conscience, and freedom of association, to give us an understanding, a better understanding of what they look like. So when we look at the right to freedom of speech, Article 29 refers to the right to freedom of speech. Article 29 of the Constitution refers to the right to freedom of speech, including freedom of press and other media. So you can't talk about freedom of speech and not talk about a free press, a free, credible, responsible media space. And I'm referring to General Comment 34 on the right to participation, which speaks into this right to freedom of expression and opinion, and says that it is indispensable and is essential for any society to thrive. Because this is the way that people are able to convey their messages, their thoughts, their opinions, and their ideals. And that is how policy, laws are eventually formed. The freedom of speech also promotes accountability, transparency, and gives room for dialogue. We keep on talking about dialogue. We must dialogue, and some people say, too much talking, when will the talking stop? But I keep on saying that as long as we have chosen to be a democracy, we cannot avoid dialogue. And dialogue is not only with those that we agree with, but those we disagree with as well. We have seen, and this creates, it de-escalates tensions, because if people cannot speak, the next action is that they will pick up something, because those emotions, that expression must come out somehow. So if people do not speak, unfortunately, the option is violence. And we know that violence is not good for any of us. And I'm saying that we have seen the courts address the issue of the right to freedom of speech and media through cases like Andrew Mwenda, an attorney general, which declared the criminalization of sedition as unconstitutional. We have the case of Human Rights Network and others versus Attorney General, and Uganda Journalists Association, Timothy Murungi and Henry Sekanjako versus Attorney General, CDF, and others, which found that stopping the press from doing their work was unconstitutional. So for Uganda, especially at this time, the right to freedom of speech speaks to the ability of ideas to be expressed between candidates, between representatives, and between the citizens without restraint or censorship. So the idea of censoring media, of censoring speech, is an infringement and violation of this right. It's also important to note that expression and opinion cannot exist outside of access to information, which is guaranteed under Article 41 of the Constitution. Again, we have seen the courts pronounce themselves on the issue of access to information, Greenwash versus Attorney General. You cannot automatically block access to information just on the basis of confidentiality. People have the right to access this information and make an informed choice. And this enhances transparency and accountability. If stakeholders know that whatever I'm doing, whatever decision I'm taking, the public can access it, they are more likely to exercise their responsibility judiciously. And then there's Sechewa versus National Forestry Authority, where a journalist successfully sued for lack of response to an information request. Again, this was an attempt to see how robust our legal system is. Is it enough for me to make the request? What happens if that request for access to information is not granted by a public body, what recourse does a person have? So we see that in order for you to have the freedom to speak, because you shouldn't just speak, you should speak within a context. You should speak within with information that guides how you speak and how you engage. And then there's the issue of freedom of thought, conscience, and belief. And I believe Dr. Ernest will speak more in detail into this issue, conscience and belief. But it's basically interpreted within religious beliefs and opinions. And general comment number 22 offers a wider and deeper interpretation to this. And basically, there are no limitations to this right. You can't force me to think a certain way. You can convince me, you can persuade me, but you cannot force me to think a certain way. You cannot control the way that a human being thinks. And so I am saying that these are protected unconditionally from any kind of interference, as it is inherent for everyone to hold an opinion. And these opinions are formed from the ability to have a conscience. What guides what I am thinking or expressing? So the only way that this right can be restricted is when it is necessary for public safety, order, and security, as provided under the Article 43 text, which we will look at a little later. Freedom of association, what does this look like? So there is no general comment, and when I talk about general comments, I hope we're all aware what these are. The United Nations does provide general comments to guide states and duty bearers in the interpretation and implementation of these different rights outside of the instruments, the regional and international instruments. So I'm saying that there's no general comment on the right to association, but there's an ongoing draft from the United Nations, and it's at the stage of parties giving their comments. And this move was made after a series of comments and observations made by civic societies and special rapporteurs who form part of the mechanism through which human rights standards are upheld, and to understand how much this right was being abused by state organs. So association, what is association? It's defined in the UN report of the Special Rapporteurs on Right to Freedom of Association and Peaceful Association, that's June 2023, as any group of individuals or legal entities brought together to collectively act, express, promote, pursue, and defend common interests. So it encompasses both formal organizations such as clubs, charities, churches, advocacy groups, any group that comes together for a common purpose. And I'm saying that the absence of a definitive interpretation document can present a gap for us, but as we've said, there is that work that's ongoing to have a general comment around it, and I'm sure it will guide us better on that. So that's on the freedom of association. The concept of interfering into the enjoyment of this right, means that state actors are allowed to intervene in situations where it is deemed necessary. Again, here we're talking about the limitations to enjoyment of this right. But I must say that these limitations should not apply in a manner that is, for example, tribal or, in a manner that is divisive. You cannot force me to associate by a particular, tribe or color, party color, allegiance. And so we've observed that Uganda grapple with this right of association, the right to freedom of association. And here I ask the question, we have a situation currently where parties are required by law to subscribe to IPOD in order for them to access certain state resources. Must I be formally a part of this in order for me to associate? Can't there be regulations that guide how I associate? Because association has a lot to also do with a convergence of minds, a convergence of purpose. So if we're from different parties and I feel very strongly that I do not want to associate in this manner, can the state force me to do so and hang finances or economic rights over my head? So my question to us is, can people be forced by law to associate? Isn't that an infringement on that freedom? Under Article 29, we have other rights which relate to the right to freedom of participation, and these include the right to assemble, the right to demonstrate, and the right to freedom of movement as they are enlisted in the Constitution. And in Uganda's context, we have had several petitions in court challenging laws and provisions that hinder the ability of persons to carry out their mandate, promoting democracy, and for different reasons. For example, in James Ranyarare and others versus Attorney General, Section 13.2 of the Political Parties and Organizations Act was declared unconstitutional on grounds that it violated Article 38, which we have referenced earlier on, which permits all persons to participate in their civic duties. That particular section was prohibiting people who live in the diaspora who had within 3 years or more from standing for political positions. And the court found that there was no rationale for this provision. Another example is the case of Kalali versus Attorney General. Again, this is to do with persons living in the diaspora, and unfortunately, we still haven't yet made enough progress in this area. We are all aware that even in this election, persons living in the diaspora will not be able to exercise their right to vote. Although the courts have pronounced themselves on this issue, we find that there are limitations structurally. Electoral Commission will tell you that there's no legal framework within which to enforce this right, and then government will tell you the cost of doing this is very prohibitive. However, I'm happy to note that NIRA is at least is rolling out the issue of issuing national IDs to persons living in the diaspora. I believe that is a positive step, a start to at least seeing that eventually our friends in the diaspora will be able to exercise this right. Let me move on to the issue of freedom of assembly. And again, I'm referencing General Comment 37, which speaks to the right of citizens to express themselves collectively and individually. And of course, that means that people must be able to congregate. So people must be able to have peaceful gatherings with non-interference with state organs. Again, we are aware that within our context, this is one of those rights over the years, right from the Public Order Management Act and some sections of the Police Act previously. There's been a lot of engagement in our courts to see that the right to freedom of assembly is respected. We are persuaded by the general comments that I've mentioned that that the right of assembly forms an integral part of a system of participatory governance based on democracy, human rights, and the rule of law. There must be something that pushes somebody to say, I must express my views on this issue or my dissatisfaction on this issue. And so the state has a duty not to interfere in such a space. The only permissible grounds for interference is where there's a breach of the peace. And again, I'm referencing that case, Human Rights Network and others versus Attorney General, Constitutional Petition 56 of 2013, where court observed that while determining whether there is a breach of peace, the question on imminent harm needs to be answered. Now, practically on the ground, we know, and if you engage with police, they'll tell you, we see these crowds growing and swelling, and we sense that there may be a possibility of the breach of the peace. There's also the argument about balancing the rights of those who are engaging in peaceful protest and the rights of others who are doing their other work and moving about doing their other business. So, of course, in this situation, the standard is whether this limitation is demonstrably justifiable. What does demonstrably justifiable mean? mean? It means that you must be able to show an independent arbiter that these actions were necessary, they were lawful, they were reasonable, they were timely. So, in most cases, in many situations, police officers have to make that decision in the heat of the moment. And many times, as Uganda Human Rights Commission, that is the question that we'll be asking. Was it necessary? Yes, for example, recently in Kawempe, if you watched how that campaign started, police had deployed, which is within their right to do, and people had started moving towards the National Unity Platform head office. And things were moving well. Then the numbers grew as they moved towards the bypass. There was traffic. The traffic, basically, you couldn't move at all. And then they moved towards the venue. And according to police, the venue got full. And because the venue got full, police stopped people from accessing the venue. So there's legitimate concern there. There could be a stampede. There could be, if anything happened, people may not be able to easily exit the premises. So it was reasonable for the police to say, the premises are full, we will not be able to allow any more access. Unfortunately, the people charged up, as is expected in a campaign season, then react. Why are you stopping us? Why are you, And then we see the scenes that unfolded. So as an independent arbiter, looking at that circumstance and looking at all the facts, would you say that the actions of the police were justifiable in the circumstances? Okay, a decision has been made that you must disperse this crowd. Must you disperse it using sticks, such as we saw happening in Gulu recently? Must you disperse it using live bullets? Is there anything that justifies using live bullets with firing live bullets in a crowd that is unarmed? Okay, the police will say they were throwing stones. What action could have been taken to counter that before the situation got to that point? That's why we see that it's very important to have the candidates calling on their supporters. Do not provoke the police, do not antagonize, because once such an action happens, things degenerate very quickly. So the point I'm making here is that whatever action, whatever limitation is taken should be demonstrably justifiable. So it is important, because I sometimes hear people saying, what is the point of issuing statements? It is important that it is on record that this is what happened. I also saw people on Twitter saying, Uganda Human Rights Commission, you're always calling for investigation. It is important that the facts are clearly ascertained. What happened? What led to this action? Was it justifiable? Was it excessive? Was it reasonable? Was it lawful? Those questions must be answered so that you protect generally both those enjoying the right, but also those who are enforcing, because sometimes, unfortunately, they also get hurt. So I want to talk about the duty of the state to protect and promote, because many times people may wonder, why do we hold the state accountable? It is because the state is the primary duty bearer in the promotion and protection of all these rights, not just the right to political participation. It's just that right now that is what we are talking about. The state is the primary duty bearer. And the state chooses, and that's why we hold them accountable, because they choose to say, yes, the values and principles in the ICCPR, we subscribe to them. And then they make a commitment to domesticate those principles and to ensure that they are enforced. So the state is duty-bound to protect. It must take steps to prevent abuse by others through legislation, through investigations, like I've talked about, enforcement of human rights, and providing appropriate redress mechanisms. And that is where institutions like the Uganda Human Rights Commission come in. Institutions like the Electoral Commission right now is the one that is in the hot seat. We have to interrogate the processes, the remedies, the mechanisms available, are they effective? Are they effective in ensuring that we protect this right to political participation? The state is also duty-bound to refrain from violations. So that is why we must hold them that's why we come out and ask, what happened? Why we are seeing the army, yet we know that it is the police that is responsible under Article 212 for these actions? Why is the army coming in? What threat is there? The state has a duty to refrain from violation. And then the state has a duty to fulfill. So it must take active steps to ensure the enjoyment of these rights. And I'll not belabor Article 20 of the Constitution, Article 6 of the African Charter on Democracy, Governance and Elections. You can look at those, and Article 17 as well, which require state organs to establish mechanisms that offer redress from election-related disputes, the government to set up agencies such as the Uganda Human Rights Commission to ensure that situations that entail the violation of rights are heard, determined, and there is appropriate remedy given. So let me speak quickly into the issue of limitations. Generally, I think I've spoken into it as I've spoken about the different rights, but generally speaking, we know that this right to political participation is not absolute. There are limitations within which it may be restrained, and those are provided for under Article 43 of the Constitution. And it talks about the public interest. Let me read that verbatim, because that is the core standard by which we consider whether a limitation is justifiable. Article 43(1) says that in the enjoyment of the rights and freedoms prescribed in this chapter, no person shall prejudice the fundamental or other human rights and freedoms of others. That is one. So we've talked about a situation where others are going about their business. They want to have access, or freedom of movement, and your enjoyment is impeding that. And then the other circumstance is public interest. And what is public interest? Because whereas Article 43 talks about what public interest is not, because public interest does not include political persecution, it does not include detention without trial, and the demonstrably justifiable test in a free and democratic society. If we claim that we are a democratic society, whatever limitations we impose, we must show that they are justifiable in ensuring that they don't harm the enjoyment of rights and freedoms of others or the public interest. And I'm saying that there is a gap in the fact that the term public interest is not specifically defined. Yes, we may talk about demonstrably justifiable, but we've not had a lot of case law come out to build up on this issue on what amounts to the public interest. And I think it would be good for us to have a sense of some guidelines that show that this amounts to the public interest. Of course, it cannot be exhaustive, but it can guide. But generally, it differs on a case-by-case basis. So where matters concerning human rights are left undefined, the mandate of the state then falls on them to protect, and where they do not do that, they have failed. So outside of the legal limitations, for example, the legal limitations such as we now have the Computer Misuse Act, and it does provide certain limitations. The Public Order Management Act does provide certain limitations. We have those limitations within the law. But I also want to speak into some of the limitations that may not be within the law. For example, we have a decision in Kalali versus Attorney General saying that prisoners and people living in the diaspora should be able to vote. But practically, we know that this election cycle, they are not going to be able to vote. Why? So there's a limitation there. And what is the reason? The Electoral Commission tells us that there's no framework within which these rights can be realized. But also there are the financial implications, the implications of having people vote at every embassy or mission of Uganda is something that has to be planned and budgeted for, and the state must be willing to invest those kind of resources into it. But again, you look at prisoners. You have all these people in one place. Do you declare the prison as a polling station? What about people come from different areas? What happens when they leave prison? So there are some of those challenges that we see are actually failing realization of some of these rights. In Kasozi Robinson versus Attorney General, similar questions arose in relation to discrimination of voters in minority groups, youth, persons with disabilities. I don't know if the army are discriminated in that way. That ability to participate in the affairs of my country. How are our polling stations designed? Can persons with disabilities actually exercise their right? If a person is blind, what mechanisms exist to support this person in order to be able to exercise their right to vote? And in that case, court emphasized that it was the duty of Parliament to enact laws that support this, and so it is our responsibility to hold the state accountable in how far these actions have gone. But as of now, that remains a limitation. The issue of campaign spending, the amounts of money that are used in campaigns, is another limitation, because you find that the people who just cannot, they are so willing to participate, but elections have become such an expensive venture that you can't. So this is a limitation on the right to participate. And we are arguing and saying, can we have a cap on campaign financing? Can we have some regulations around campaign financing? And this is something that has not yet been realized. Issues of access to information, former limitation. We are all aware of the internet shutdowns and situations like that, even slowdowns. There have been people who have raised questions around jammers, around certain spaces. Again, this is a limitation. The question then becomes, is it demonstrably justifiable? The issue of access to campaign venues was discussed in Amama Mbabazi versus Kaguta Museveni, and maybe, for example, some media houses not being given access to certain candidates. All those are limitations. So what are the prospects? Or what can we recommend? Of course, we always start with the law. Outside of a legal framework to address these limitations, you cannot do much. And so we call for legal reforms. And as I've emphasized, we feel that campaign financing needs to be regulated. If we are going to have participation across the board, you can't have a 25-year-old sinking 100, 200, 300, 500, 1 billion shillings into a campaign. They're just going to steal. They're going to become thieves if they are to do so. And what kind of representation will we then have? We are also aware that there are guidelines that were provided in the Supreme Court case of Amama Mbabazi that have not yet been fully realized. Yes, this cycle may be too late, but we still need to push to see that all the recommendations that were given by the Supreme Court in that decision are fully implemented by the Electoral Commission and by other stakeholders. We need stronger checks and balances, particularly for the police, because of how they interface with the public in this area. When you interface with the police, they'll tell you we have internal mechanisms that provide redress. Where an officer is errant, they are taken through our disciplinary processes. They may be demoted. They may face criminal charges. But there is a sense in which the public is not fully aware of these actions when they are taken. And so that disgruntlement remains within the population. And so we feel that there's a need for more accountability. Yes, we know they are doing the press briefs whenever there's an incident every Monday. They are giving information. We appreciate that, but we think that we can still have stronger regulation of these actors. And then I'm also recommending stronger self-regulation of media houses and journalists. I personally believe that self-regulation is the best mode of regulation. If the media houses regulate themselves by making sure, especially now at digital age and everybody is a journalist, everybody can report, we need to see that we are having stronger regulations so that there is no justification or there's no abuse of these rights and freedoms. I recently saw on Twitter, there's this, I don't even know if he's the one, because that's part of the challenge with Twitter. You never know if it is factual or not, but someone had pulled out one of an civilian participated in the Gulu incident. They had pulled out pictures of their children and had posted them online. Now, regardless of how annoyed you are, for you to pick the photos of an innocent child, place them on a public platform in order for you to express your dissatisfaction is wrong. And two wrongs do not make a right. You cannot justify vilifying these children. Those images are permanent. We don't know where eventually they end up. Those children could be traumatized, and those children are not responsible for the actions of their parents, if at all that person is even the one. That information has not been verified, but it has been shared and broadcast far and wide. So there is a need for us to regulate ourselves, to regulate our internet use, to regulate our language, things that incite violence, so that the state does not, the moment the state comes in, definitely those measures will be harsher and more stringent. So we need to regulate ourselves, especially in this digital age. And finally, we need to support our redress mechanisms. As Uganda Human Rights Commission, it currently takes us on average 7 years from the time we receive a complaint to the time it is heard by the tribunal. In those circumstances, you cannot say that you are providing redress. Many times, by the time these matters come up for hearing, the complainants have died, or they have lost interest. Witnesses have died. So, in as much as a lot of effort is being made to improve the judiciary, handle backlog and issues like that, even institutions that are responsible, like the Uganda Human Rights Commission, like the Electoral Commission. Right now, actually, Jennifer cannot be here with us because they are swamped back-to-back hearing these complaints. But then again, it raises questions. Is the Electoral Commission the most appropriate body to provide redress? You're the one who is superintending the election. You're the one who's providing redress. Is that fair? Is it just? Those are some of the questions that we need to interrogate and address our minds to. And with that, I'd like to thank you so much for listening to me and to welcome questions and comments. I thank you.
Thank you very much, Ms. Pauline Nansamba. Can we have a round of virtual applause for Ms. Pauline's presentation? Thank you for that very enriching conversation. As stated, and the members agree upon, this couldn't have come at a better time. Members, we have been encouraging you to post your questions in the chat so that Ms. Pauline can address them. We have a hand up, Ms. Agatha Tusime. Yes, please, you can ask your question. Let's be brief while asking these questions. Okay. Agatha, we are unable to allow you to ask the question, to unmute and ask because of a technical glitch. However, please go ahead and type your question in the comment section, and Ms. Pauline will be ready to answer it right away. We had a question earlier on during the presentation, and that is from Edmond, and says, why are human rights advocates only politically centered? Yet there are many suffering from within their homes, police cells, workplaces, and so. Ms. Pauline, I think, would you like to take the question one at a time, or?
I could have maybe three.
Okay. As the rest are continuing to type, there is also someone who said, there are many young lawyers online. What opportunities are there as a human rights practitioner, and how can they tap into human rights practice? I think you can answer these ones as the rest continue to type.
Thank you. Thank you very much, Edmond. Why are human rights advocates focused on political rights? First of all, today's discussion was about political rights, political participation, and I think at some point in my presentation I did mention that there are a broad range of rights that we must consider, but for today's discussion and the environment that we're in right now, we're talking about political rights. As Uganda Human Rights Commission, actually, one of the major messages that we are trying to send out is that economic, social, and cultural rights are just as important as political and civil rights. That is something that we emphasize. Because if I do not have, for example, right now we're talking about participation. I didn't go into disaggregating issues of women. I'm actually traveling to Kalangala after here. That's why I need to leave. We're going to talk to women in Kalangala. When you have people who cannot access a health center, many deliver in those boats on those waters, cannot have access to a school, cannot have access to basic services, and you think that such an individual is going to be able to even have the presence of mind to form a conscience, to form an opinion, to form a thought, and to express it, it's not possible. They are simply surviving. So if we do not address economic, social, and cultural rights, it definitely affects the enjoyment of civil and political rights. So there must be that balance. Why do we focus on political rights? Again, I want to lean into that a bit more and say that in all of these human rights issues, human rights are inherent. They are not given to us by anyone. They are enjoyed by virtue of being human. However, the duty to protect and promote lies primarily with the state. That is why I made that comment and said, the state goes and makes these commitments, democratic principles, freedom of participation, association, expression. So we must hold the state accountable for their commitments, because they are the ones that regulate the environment within which these rights are enjoyed. That does not take away the responsibility from us as rights holders to actively and proactively seek the realization of our rights. So for example, you can't say that because the state has a duty to ensure that I enjoy my right to maternal health, I will wait until the last minute and go to the hospital when things have already gone bad, and then I'll say the state was responsible. I also have an obligation. However, the state has an obligation to make sure that within a certain perimeter, I have access to a health center, it is stocked with drugs, it has competent medical personnel. An individual cannot do that. It is the state. Because remember, the state acts collectively on our behalf. That is why we entrust them with this responsibility and say, you are our government. And that is why we have the right to hold them accountable. I hope I've answered that. I can go on. This is a subject I'm very passionate about, so I can go on and on and on. So you need to manage me. The issue of opportunities in human rights. We were actually talking about this earlier with Jackie, the moderator, and I was saying that the beauty of the law is that there are so many opportunities and avenues. In the human rights space, there is national human rights institutions like ourselves, the Uganda Human Rights Commission, but there are a lot of civic stakeholders that we work with. Human rights is as wide as, I don't know, I usually say everything is a human right, from palliative care to access to information, the rights of children, persons with albinism. There is an area for you to develop in any area of your passion. You can actually make yourself into an expert in that area. There are international and regional mechanisms within which we feed. So if that is your interest, you can also go in that direction. But my appeal for us would be that the greatest need is at the grassroots. So there are so many people who do not have access to this information, who are not knowledgeable, and you can provide them with that insight as a lawyer. And it's a good area of practice, though it's not the most lucrative, I like to be honest. If you're the kind of person who wants to make good money, I'm not sure human rights is your area. But if you're passionate about people and how we live a full life, then human rights is a space for you.
Thank you very much, Ms. Pauline. We have some comments in the comment section. Mr. Molly Albert Sivuta says, topic well digested. There's a question that we have from Paul Asimwe. He says, the constitutional guarantees around political rights assume that the public is aware of these rights and can effectively participate. What can Uganda Human Rights Commission do to ensure that civic education is not done in a more timely manner? So civic education is done in a more timely manner so that it has the desired impact.
Thank you, Paul. That's a very, very good question. Within this election cycle, that is one of the challenges that has been highlighted, the absence of sufficient civic education. It's true, the mandate to conduct civic education lies constitutionally with the Uganda Human Rights Commission. We do our best within the resources that are available. But what I want to say about civic education is that we need to think beyond the election cycle. Because when you start to do civic education, even if it is 2 years to the election, you're late. When you're talking to people about their right, their inherent rights, their duties, their responsibilities, their obligations as a citizen, those are things that cannot be panel beaten. They actually need to come right from childhood. When you look at the Americans and how robust their democratic system is, I mean, they also have issues, but a child is proudly American from day one. They are proud to defend the ideals that their constitution stands for from day one. I want you to look at our population and tell me how many of us understand what it even means. When we say we are a nation, what do we mean? What makes us a nation? So for you to now come 2 years to the election and start telling this person, yes, you have a right to vote. Yes, I have a right to vote. But I have not gone to school. I'm struggling with soap and water. Can I really, when we talk about freedom of thought, of conscience, am I equipped? And that is why it is so important, even some of these other rights, the quality of our education system, our education policies. Where is civic education in all of this? I believe it was removed at some point from the system. I'm not sure what I know we have SST, but those days we used to have civics, the coat of arms. What does the police do? Who is responsible for what? Some of those things have to become a part of you innately if you're to have a population that is civically aware. So yes, we have that mandate, but our appeal is that we need to go beyond just the 2-3 years to the campaign season and saying electoral commission now go out and do vote. Okay, yes, someone needs to know when I put my chinkumu here, what does it mean if I put a tick? That is important, but that is the tail end of civic or voter education.
Okay, thank you very much. Just one last comment before we can move to the next presenter, as we are running out of time. We have Dennis Lutete saying we appreciate the depth of the reasoning in this presentation. Robert says, very good presentation, I have gained. Linda Gidudu says, don't wait for opportunities in order to participate in the human rights agenda. You, as a competent advocate, can start your own initiatives and endeavors within your community or where there is need. But like the presenter said, it won't be as lucrative as other legal practice. However, it can create opportunities for you in the long run. Thank you very much, Linda, and thank you very much, Ms. Pauline, for that very enriching discussions. We are ready
Thank
to...
you very much for having me, and I hope it's been a meaningful engagement.
Thank you. Thank you very much. As we move to the next item on our agenda, we are going to move to the next presenter, that is Dr. Ernest Tashobia Katwesije. He is going to take us through exploring freedom of association and belief, the case of faith-based policy. I'm going to tell you briefly about Dr. Ernest Tashobia Katwesije. Dr. Ernest Tashobia Katwesije is a Christian lawyer, award-winning author, educationist, and transformational leadership or theology scholar. He is currently working with the Inspectorate of Government as the Manager Asset Recovery, having previously worked as an inspectorate officer or investigator and a supervisor prosecutions. He also serves as the president of the Society of Christian Scholars Uganda chapter, deputy minister for education in the National Fellowship of Born Again Pentecostal Churches in Uganda. And as a team leader of the Institute for National Transformation, he has authored over 20 books, 2 of which have won a national award and an African award. Ladies and gentlemen, Dr. Katwesije holds a Bachelor's of Law degree in Bachelor's of Law, Diploma in Legal Practice, Diploma in Ministry, Master's of Business Administration, and PhD in Christian Education. He is a chartered secretary. He teaches part-time at Uganda Technology and Management University, business and law courses, and at Glad Tidings Bible College, which he also serves as a legal advisor to the Governing Council and is the legal advisor to the Full Gospel Churches of Uganda. Dr. Katwesije is a member of the Uganda Law Society, East African Law Society, and Uganda Christian Lawyers Fraternity, which he has served in various capacities over the years, including Chief Editor to the UCLF Annual Magazine, Chair Publications Subcommittee, Member Editorial Board UCLF Journal, and Vice Chair Membership Subcommittee. Ladies and gentlemen, join me in welcoming Dr. Ernest Tashobia Katwesije. You're welcome.
Thank you. Good morning to us. And ladies and gentlemen, it is a pleasure to speak to you this morning on a very key topic in this period, exploring freedom of association and belief, the case of the religious organizations policy. Okay. How does it work? Okay. Freedom of association and belief are fundamental rights that are guaranteed both by the Constitution and by international law. And as a country, we have enjoyed varied levels of respect of freedom of association and belief over the years. We've had periods that way there was suppression, and also periods where there was respect of the rights. And you would say that today we are reasonably enjoying freedom of association and belief. However, we currently have no harmonized law or policy in relation to religious and faith organizations. but we have a draft policy which is meant to provide oversight. So a background about freedom of association and belief. Freedom of association can be said to be the right of individuals or groups to voluntarily form, join, maintain, and live organized groups such as religious organizations, political parties, trade unions, etc., without undue influence from the state or third parties. On the other hand, it can be said that freedom of belief is the right of every person to hold, adopt, change, manifest, or reject any religious or non-religious belief, individually or in community, publicly or privately, without coercion, discrimination, or state interference. In other words, a person should be able to choose, or even to unchoose, or not to choose at all, to belong or not to belong. The two looked at together, you would say that freedom of association and belief, which are closely related, are constitutional and internationally protected rights of individuals to form and join organizations of their choice, especially of a religious nature, and to freely hold, adopt, change, and manifest their religion or non-religion individually or collectively, publicly or privately, without coercion or unjustified state interference. I should be able to decide whether I want to practice my religion privately or whether I want to practice it publicly or corporately. I will go through a few of the constitutional provisions that are directly relevant. Article 29(1) tells us that every person shall have the right to freedom of thought, conscience, and belief, which shall include academic freedom in institutions of learning. Okay? Thought, conscience, and belief, and that's where aspects like wanting to control what someone calls false religion becomes complicated, because I decide what is right to me, you decide what is right to you. And a person have a right, have freedom to practice any religion and manifest such practice, which shall include the right to belong to and participate in the practices of any religious body or organization in a manner consistent with the Constitution. So as long as I am within the confines of the Constitution, then I should have that freedom to practice any religion, whether someone is happy with that religion or someone is unhappy with that religion. And also a freedom of association, that is E, 129(1)(e), freedom of association, which shall include the freedom to form and join associations Article 7 says that Uganda shall not adopt a state religion. That is very key. This has been translated by many to mean that Uganda is a secular state. I do not agree with that position, but it's not the subject of today. But in summary, having no state religion does not mean that you are a religious. No, it means that the state will respect all the religions that are practiced within its jurisdiction. Because one can argue that secularism is a religion itself. Article 43:1 says, in the enjoyment of the rights and freedoms prescribed in this chapter, no person shall prejudice the fundamental other human rights and freedoms of others or the public interest. Which means, as I am enjoying my freedom to associate with people that share a faith with me, I should not prejudice the freedoms of others. I should not prejudice public interests, and that's where at times the need to regulate comes in. And public interests shall not permit any limitation of the enjoyment of the rights and freedoms prescribed beyond what is acceptable and demonstrably justifiable in a free and democratic society, or what is provided in the Constitution. Any checks should be justifiable in a free and democratic society such as we live in. There are few international conventions that I will talk about. The International Covenant on Civil and Political Rights, Article 18, every person shall have the right to freedom of thought, conscience, and religion. This right shall include freedom to have or to adopt a religion or belief of his choice, and freedom either individually or in community with others, and in public or private, to manifest his religion or belief in worship, observance, practice, and teaching. So I should have the freedom to express my worship in a manner that I am comfortable with, as long as I am not infringing on my neighbor's enjoyment of their own freedom. No one shall be subject to coercion which would impair freedom to have or to adopt a religion or belief of one's choice, and the freedom to manifest one's religion or beliefs may be subject only to such limitations as are prescribed by law. Okay, so number one, the limitations to the freedom of belief or religion should be prescribed by law, but should also be necessary to protect public safety, order, health, or morals, or the fundamental rights and freedoms of others. During COVID, we saw instances where some religious beliefs did not agree with the concept of vaccination, or did not even agree with the concept of social distancing, and definitely that was a health risk that required government intervention, and it so intervened. The state parties to the present covenant undertake to have respect for the liberty of parents, and when applicable, legal guardians, to ensure the religious and moral education of their children in conformity with their own convictions. Okay, so a parent should have that liberty to raise their child in a manner that they deem religiously appropriate. At times, an issue that has come up in relation to this, for example, is homeschooling. Some parents believe that the only way to give their children proper religious instruction is by homeschooling. And the numbers are growing. Of course, it's not regulated currently. The proposals that have come on table have largely tried to suppress it as opposed to providing a framework for it. But definitely that would be an infringement on this specific provision. Article 22, everyone shall have the right to freedom of association with others, including the right to form and join trade unions for the protection of their interests. The Universal Declaration of Human Rights, Article 18, everyone has a right to freedom of thought, conscience and religion, including freedom to change religion or belief. And Article 20 speaks the right of to freedom of peaceful assembly and association. And no one should be compelled to belong to an association. In terms of freedom of belief and association, there has been questions whether religious bodies should be part of an umbrella body. But that would definitely be an infringement of the freedom, because a religious body that wants to be independent would find itself being compelled to join an association. The African Charter on Human and People's Rights, Article 8 talks about the freedom of conscience, free practice of religion to be guaranteed. And Article 10.1 talks about every individual having the right to freely associate, provided that they abide by law. We have the UN Human Rights Commission General Comment number 22, which specifically guides that internal freedom should be absolute and that the state should remain neutral and impartial in matters of religion. Then General Comment number 4 on freedom of religion, restrictions must not target or favor any particular belief system. Okay, so they should not, although I'll talk about it a little later, at the onset of the process for developing the current draft policy, there was talk of mushrooming groups. These mushrooming groups need to be checked. Definitely a policy that comes in that light is targeting a specific group. Good enough, those such references have been removed from the current draft, but definitely the spirit remains looming in the air, and it may not be that easy to convince someone that it is not targeting them. Okay, so when we talk of principles in relation to freedom of belief, we've already talked about internal freedom. It is an absolute right to hold or change beliefs, and it cannot be restricted under any circumstances. This protects thought, conscience, and personal conviction. On the other hand, you have an external manifestation, which, whereas protected, requires regulation. Think of worship. Worship it in itself may not be regulated, but the mode in which you practice it may be regulated. some guidelines might be needed to be in place, but it can also only be restricted in a manner that is lawful, necessary, and proportionate, not just to appease a particular group. Okay, of course, our principles of freedom of association, voluntary formation, autonomy in governance. Again, this is something that creates a challenge in trying to come up with a uniform policy. If there is autonomy in governance, then how will you promote that? How will you unify non-discrimination in registration, right to exist without forced affiliation, freedom to mobilize resources, and protection from arbitrary dissolution? A clear conflict that I can see coming up is between those that are considered mainstream versus those that are considered either upcoming or independent groupings. How do you put them within the same framework? It's not an easy thing to do. So again, as I mentioned earlier, Article 43 of our Constitution, limitations to freedom must be demonstrably justifiable in a free and democratic society and should not be based on political, cultural, or religious intolerance. We can talk about what some countries have done. In our neighbors, Kenya, faith-based organizations are registered as organizations. They have a voluntary umbrella association recognized by government, but voluntary. There is a minimal state intervention, but they are close. Of late, we are seeing closer monitoring after chaotic activities that involved loss of life. Of course, in Uganda, we have had those before. So the lessons from that is that faith organizations can thrive with moderate government intervention, but there is need to promote rule of law, even as we deal with them. Rwanda, of course, we know what is happening in Rwanda. Strict control, largely influenced by the past, where the church was considered to have been complicit in genocide. We have a very strict registration regime, and we have requirements for academic qualifications for leaders of faith, and the faith organizations must be involved in social development initiatives. We've seen thousands of churches, mosques, etc., closed for non-compliance after grace period, but we've also seen those that believe that they have been compliant also being closed. So it is generally felt that the state is beginning to infringe on the freedom of belief and association. Some lessons from Rwanda: it's important to have a unified position so that we can move together. Faith organizations ought to operate responsibly. However, over-regulation can be counterproductive and can infringe on freedom of belief and association. South Africa is an interesting case because their constitution guarantees freedom of religion, belief, and opinion, and the right to exercise one's belief However, the right may be limited by law of general application for reasonable and justifiable in an open and democratic society. You have religious associations registered with the Department of Social Development as public benefit organizations, and they enjoy tax exemptions provided they meet reporting standards. They must maintain accurate registers of members, leadership, and assets. And this must be filed with the government. And they are also required to archive all board meeting minutes and resolutions as well. So there are requirements. So with South Africa, we see that there are guidelines on how they should operate without getting into the aspect of the faith itself. If the faith organization receives or handles funds above a prescribed threshold, they must register as accountable institutions. Of course, even in Uganda, churches ought to, and religious organizations ought to register as accountable persons. I'm not sure how many have done that. They are required specifically to approve an annual budget sanctioned by the board, have internal and external audit frameworks, and keep financial records for at least 5 years. So we see that from South Africa that there are requirements for accountability, but government can partner with faith organizations to enhance this accountability. But there is respect for freedom of religion and belief, and government intervention therein is minimal. So let us get to our draft religious and faith organizations policy. We have a draft religious and faith organizations policy currently under review that has been developed through, you could say, a long process that has been spearheaded by Ministry of Ethics and Integrity that started since 2013 through stakeholder engagement, extensive studies of framework. Yeah, and you can say that when you go through it, a lot of work has been put in, but we still have considerable opposition to it because, for example, to date, the Interreligious Council for Uganda has rejected it. And this has mainly stemmed from the nature of consultations. I have listened in to one of the consultation meetings with the religious leaders, and in my view, it didn't qualify to be documented as a stakeholder consultation, because if we have an engagement and you just give the headlines and then you document that as consultation, then definitely there is a problem. So we have an elephant in the room. Is the policy promoting responsible expression of faith, or is it infringing on the right to assembly and religion? That is the question that we must answer. Of course, we have an interesting legal framework for faith and religious organizations in Uganda that is neither here nor there, and is there and here and nowhere and everywhere. You have most of the traditional faiths registered as trusteeships under the Trustee Incorporation Act. Today you have most of the groups that are being registered today being registered as companies limited by guarantee. Previously you had some registered as NGOs, but the NGO Act was amended to exempt them. We have a number that are unincorporated, unregistered. When you look at the NGO Act, it specifically envisaged that a special law for FBOs would be put in place. Of course, each of these vehicles is problematic. The Trustee Incorporation Act mainly relates to land. When you talk of companies limited by guarantee, who are the members that are respected? We had an interesting case a few years ago where a court ruled that the persons registered in the memorandum and articles of association were the members of the church. The rest of the congregation that had brought money to build and that was sustaining the ministry, they were just well-wishers. Makes sense when we look at company law, but in the grander scheme of things, does it actually make sense or not? So what are the concerns of the state in introducing the religious and faith organization policy? Of course, we see that there's notable absence of comprehensive guidance for government interaction with and support of RFOs in the collective progress of the nation on one hand, and also the absence of uniform framework to register and regulate religious and faith organizations. I already mentioned that that can actually be complicated because each group operates differently. Some have been here for over a century, some are young. And then lack of a coherent and inclusive national policy to guide regulation, coordination, and strategic engagement of religious and faith organizations. Which gap, I use the word purportedly, has purportedly led to fragmentation in registration systems, limited state oversight, abuse of religious platforms for exploitative or unethical purposes, and underutilization of their potential in national development planning. I use purported because I don't think so. I think that even within the current legal framework, there is adequate provision to deal with this. Oversight, we have laws that provide for oversight of organizations. You have a whole spectrum of laws on that criminalize acts that can be looked at as fraudulent, but which we have not seen implemented. It has allowed manipulation of followers, financial impropriety, and disruption of public order by a few unethical actors. Okay, this is the language of the draft policy. So if regulation is guided by those few unethical actors who can anyway be got using the existing law, then maybe we need further motivation for the policy. You also have a lack of comprehensive regulatory framework, weak structural and accountability standards, limited formal training for religious leaders, which is again another complicated issue. Who decides what training a religious leader should have? Is my faith, if my faith has set these principles, then how does someone subscribing to a different faith train me? Maybe we need to reconsider whether we need formal training. Can training not be formal? That's food for thought. Negative foreign influence and the growing trend of moral decay and impunity. Again, like I said, these are real issues that can be addressed if there is a political will to address them. So in the absence of deliberate policy guidance, these factors continue to undermine the ethical fabric of society, disrupt community cohesion, and compromise the credibility of genuine religious work. That is the view of the policy developers. Though we might need to also ask, what is the impact in relation to social cohesion of adopting a policy in the manner that we have taken? The goal of the religious and faith organizations policy is to enhance accountable leadership within religious and faith organizations while establishing a governance framework that promotes ethical conduct, legal compliance, and effective service delivery for national development. So one also begins to think, aren't we having too much fusion of state and faith? You know, that is food for thought. The objectives to promote a culture of transparency and accountability, that is good enough, because definitely there ought to be accountability. Facilitate collaboration for national development. This is a tricky situation. Where do you start? Where do you stop? We have seen faith organizations given money for development and it's abused. For example, in such cases, isn't employing the hand of the law to put such a faith leaders in line, doesn't it cause more challenges for social cohesion? You know, we've seen court cases involving religious leaders. The followers look at it as an attack on their faith, actually. So maybe we need to try and keep the two as separate as possible. Promote unity and harmonious coexistence, and provide a framework of registration of all religious and faith organizations in Uganda. The policy proposes a religious and faith organizations board picked from among the religious and faith organizations. That's another challenge. How do you pick it? Which faiths will you consider? The minority groups will also feel left out. So how do you make sure that everyone is catered for? And as this team is determining a registration, is determining policy, how do you ensure that everyone's interests are catered for? Not an easy thing. So the concerns that have been raised about the policy include a potential violation of freedom that we are talking about, because when you get into trying to regulate how a faith organization should operate, aren't you actually infringing my freedom of belief? When you impose state control, aren't you going against my very freedoms that the Constitution has guaranteed to me? Discrimination, I mentioned that in various engagements, reference, for example, has been made to mushrooming born-again churches that are seeming out of control. Now, this I should commend the ethics ministry that they have removed some of these extremist expressions, but unfortunately they are already in the minds of the population, and the promoters of the policy, a number of them make reference to these. So that seeming targeting of specific groups raises questions of discrimination. And of course, this gets to also the international obligations that I already talked about, so I'll not go into those in details again. But then there's also a feeling that we have an adequacy of laws to deal with the fears that the policy raises, and a need for more sensitization, more consultation. I mentioned earlier that consultation, especially with the religious leaders, was done in a bit of a hurried way. IRS, Interreligious Council for Uganda, for example, believes that they have not been consulted effectively. When the policy tries to address criminal accountability, don't we have laws in place already for all and each of the issues that has been raised? I talked about discrimination and appearing to target specific groups. So in light of that, definitely, I would say that definitely a religious and faith organization's policy is needed. But we need to take into consideration the right to assemble and belief or religion. Attempts to regulate faith itself are uncalled for, and so it should focus more on governance aspects for these faiths rather than regulating the faiths themselves. We should have a proper, full consultation with a mind that is ready to listen. And we also propose that a good thing the draft policy talks about promoting self-regulation, but we ought to see more of promoting of self-regulation, put standards in place and require every faith to self-regulate in accordance with those standards. I think I recommend that we drop the requirement for formal training. Definitely there should be a requirement for training of leaders, but it should not be limited to the formal primary, secondary degree diploma. We should provide for alternatives. A person that has not necessarily gone to university does not mean that they cannot effectively lead faith. And it should be inclusive as well. Thank you for listening to me and for God and my country. Thank you.
Thank you very much, Dr. Anesta Shobia, for the wonderful presentation. Please, members online, feel free to give virtual claps for Dr. Ernest Tashobia's presentation. We have a few comments online. Nayunja Sarah says, kindly requesting share presentations on our email. These presentations will be available to all the participants. And if you have questions, kindly post them in the comments section right now or in the chat so that Dr. Tashobia can address them right now before we move to the next presentation. However, just maybe a quick question to you, Dr. Tashobia. Just to re-echo some of the things that you mentioned in your presentation, how do you balance the right to freedom of association with potential limitations that has been imposed by some of our laws, for example, the NGO Act, especially in respect to some of the principles of freedoms of association that you mentioned, that is freedom to mobilize resources, protection from arbitrary dissolution and so on, since some of these faith-based organizations are being associated to political organizations and so on and so forth. Thank you.
Should I respond? Okay, thank you. Yes, so, for example, let me start with why you ended. Some of the faiths have been associated with receiving funding from politically considered political players. What's the problem with that? Don't the members of those political groupings have freedom to associate? I think the question should be, as a faith, when we get this money, are we breaking the law with it? Okay? Or are we doing what is right? You know, there should not be limitations on where we get money, unless, of course, for example, there are laws on money laundering, and those are, if fully appropriate. I work with the Inspectorate of Government, and in the past we have actually traced stolen money to one of the major churches in Kampala, and the leadership willingly handed back the money when we put to them the evidence that this was actually money stolen from government. So as long as there is no criminality involved, then faith and religious organizations should not be having interference from the state. So the parameters guarding is what should be done so that criminality is detected and is dealt with. Otherwise, the freedom of the religious organizations should be respected.
Thank you very much. Maybe just another question among the things that you highlighted in your presentation. But before I go to that, there's a comment from Nerissa Murray that says, the problem is that as Ugandans, we are getting to a point of individualism, in that if my rights are not infringed, then I won't care. Everyone is minding their business, save for the so-called idle minds who actually take interest in the inhumanities going on. All right. Thank you, Nerissa Murray, for your comments. Dr. Ernest, on the presentation that you made on limited trainings for faith-based leaders, I was pondering upon like the case scenario in Rwanda, the requirements of faith-based leaders to have a particular training. Wouldn't you consider that best case practice to protect, for example, the masses, noting the sensitivity of this matter, as a thing, for lack of a better word, to protect the masses from manipulation of the masses or the believers that are seen to be happening these days?
I hear you. Thank you. And who says that a degree holder is more religious than a P3 graduate, or who says that they are more likely to obey the law. Actually, the extremist cases we've had in the country have been highly qualified people. Think of the infamous Chiwetere incident, actually, which largely sparked off the move to try and regulate. This was a fully educated, ordained priest who had gone astray. So, is there a need for training? Yes. Must it be tagged to our academic levels? No. You mentioned in my introduction that I offer support to the 4 gospel churches of Uganda, and to Glad Tidings Bible College. For example, the college has the formal diploma in theology, but it also has a program that does not require prior academic qualification, but that equips the church leaders with everything they need to run a church, to run a ministry. That we call it a leadership development program. One does not require any prior learning. So my recommendation is that we should not tag the requirement to training to formal academic qualification. Thank you.
Okay, thank you very much, Doctor. We have another comment that is from Dr. That is from Patrick Nwagaba. He says, Doctor, if court says the members of born-again churches are those that are stated in the MEMATs of XO, that is not quite clear. Patrick, you can further expound on your comments so we can understand better. OC says, well articulated, thank you. Dan Gabriano says, hi, could you please share the names of the parties and citations of the court cases you refer to in the presentations? I think Doctor has taken note of that and he'll duly share the same. Still, Patrick says, of a company, okay, I think it's a continuation. Doctor, if court says the members of born-again churches are those that are stated in the MEMAT of a company limited by guarantee, what do you prescribe as a way forward for the faithful congregants to also have ownership in the churches they help build and maintain?
Interesting one. Definitely, my elder Dan Garano, I will share that judgment at a later time. Offhand, I do not. I know the church that was involved, but I'll share it at a later date. I definitely think that particular judgment was problematic because yes, technically the guarantors are the members of a company, but when it gets to say a church, a church goes beyond that. So what would I advise for the rest? Maybe in the drafting of the MEMATs and the articles, that should be provided for, that the church members or the faith members who are registered shall be members. They shall be members of that entity, or the MEMATs and articles can be drafted in such a manner to provide for them. Unfortunately, many times we just use the standard template and mention 3-4 names and that's all, but that can be dealt with at the drafting stage to provide for all registered members. I know that there are groups, there are churches where they have proper registers of members. So yeah, the articles can provide that those shall be members of the church as well. Thank you.
Okay, thank you very much. I believe those are all the questions that we have for Dr. Ernest Tashobia. In case you have further questions, please direct them to the chat and we shall be able to direct it to him and he'll address them at a later time. Thank you. We are running out of time, and therefore we have to move to our next presentation, and that is the case for academic freedom in institutions of higher learning, and that is reflection. This presentation will be chaired by Mr. Mugabi Ivan Kaiti. Mr. Ivan Mugabi Kaiti will be joining us online. Mr. Ivan Kaiti, can you hear me? Are you online? Yes, I'm online. I can hear you loud and clear. Okay. Yes, we can hear you loud and clear. Thank you. Members, in addition to being a full-time assistant lecturer at Kabale University in Western Uganda, Mr. Ivan Mugabi Kaiti is passionate about inspiring the next generation of writers, which accounts for his participation as one of the academics volunteering on the panel of judges for the law undergraduate essay competitions organized every year in Dublin, Southern Ireland. He is also a member of the East African Law Society, Committee for Business and Human Rights. He is a member of the Urban Law Center, a member of the Africa Climate Change Network, one of UNESCO's experts research hub, among other research communities. In terms of his education, he has a Master's of Philosophy from Cardiff University in Wales, United Kingdom, a taught Master's degree, LLM, in Human Rights from Cardiff University, Wales, UK, a taught Master's degree in International Commercial Law from the University of Glamorgan, UK, Wales, a postgraduate diploma in legal practice from the Law Development Center, and a Bachelor's of Laws degree from the Uganda Christian University, Mukono. Mr. Ivan Mugabi Kaiti also has passion for teaching, researching, publishing as a means of advancing new epistemological discourses. Ladies and gentlemen, join me in welcoming Mr. Ivan Kaiti Mugabi. You're welcome. Yes, we can hear you. Members online, can you confirm you can hear him? Just give us a thumbs up. Great. Ivan, can you hear us? Ivan? I think Ivan is experiencing network challenges. Let's give him just a few to settle. Yes, Ivan? Yes, Ivan, we have lost Ivan, but he'll be rejoining us shortly. However, let me just make a comment. Earlier on, we had Linda asking us to check the Q&A page. I hope you have received the answers. Miss Pauline addressed your queries in the Q&A chat room. Ivan, when you can hear us, just let us know. We'll be ready for you. In the meantime, you can have water breaks. Um, Dear members, we are still experiencing a technical glitch, but we are going to resume in 10 minutes. Let's have a water break as we try to sort this. Thank you. In the meantime, you can still keep your questions coming. Our presenters and panelists will address them. Thank you. Yes, Ivan, we can hear you. We are having a short water break for 10 minutes. Thank, thank you. We'll be. Yes, please. Okay, we'll be able to let you know when we are back on. Welcome. Hello, members. I hope we have grabbed our waters and we are feeling fresher and ready for the next sessions. Mr. Ivan Kaiti, can you hear us?
Yes, I can hear you. Can you hear me?
Yes, we can hear you loud and clear. The floor is yours. Please carry it away.
Yes, thank you very much. I'm going to be doing my presentation will be broken into two main areas. The first part, I'll be talking about academic freedom in as far as the issues of academic freedom relate to probably areas of maybe access to information, but also we shall get to see how do questions of academic freedom stress to students, because in an environment where we are dealing with teaching, we have lecturers, but you also have students. So we shall try to look at how the big spectrum of the big topic of academic freedom extends to students. And I will try to see, I'm also going to try to endeavor to screen share so that we are able to follow through. So time and again, we find that discussions around academic freedom have been contentious, not just in institutions, but also within entities like governments. And in that discussion, as we shall probably later on see, that there may be cases where this freedom has been limited or restricted. And so we need to appreciate maybe first and foremost, where in terms of the background, the legal framework, the institutional frameworks on academic freedom. So in my presentation, I'll give an highlight of the institutional framework, but I will also, I need to clarify that after the presentation, I will make sure that I share with the organizers with the presentation, the PowerPoint slides, which can be availed to the members. So there are three, I will break down my discussion into three main areas or three main. It will be done in three probably key areas or within. So I will look at academic freedom in the generic sense, whereby there I would simply be interested in looking at academic freedom in as far as global context is concerned, because we know questions of academic freedom, they are not really only in our country. They spread across. Sorry, I think I noticed that I was there. Yeah, questions of academic freedom are not just in our country, they spread across. And that gives us relatively, a wide spectrum of examples to pick from, but also to learn from. Meaning there are many countries across the world where questions of academic freedom have actually been quite pertinent, but also they have been quite resilient. So we may pick and borrow examples from across the spectrum, because those will give us kind of insight. But again, later on, I'm going to narrow down to academic freedom in Uganda. Uganda as a country, how have we dealt with questions of academic freedom? Why have these issues been a little bit contentious? Have they even been contentious in the first place? So in our discussion, I will try to narrow down to look at the broader knowledge on academic freedom, because that is a reality. Institutions are dealing with questions of academic freedom. Then under the discussion within the Ugandan context, I will eventually narrow down to look at academic freedom in Uganda. I will pick examples of decided cases, illustrate with the decided cases where academic freedom has been a little contentious or has manifested in our context to be somehow contentious. So that is something which I will delve into in the course of the presentation. So I will start off by looking at, I think I'm hearing an echo. Bear with me. So I'll start off by looking at academic freedom in the global or in the Ugandan context, generally speaking. Then towards along the presentation, I will narrow down the discussion from academic freedom globally to academic freedom in Uganda. And I'll begin with a quick definition for clarity. I'll begin with a quick definition for clarity, because that will give us an insight of the complexities of these discussions on academic freedom. So and I think I hope that I'm able to my screen is visible so that we are able to follow through. I want to begin by giving just a quick overview of academic freedom Well, academic freedom, we realize that it has various connotations, and to different people, it may mean different things. So it's the right of teachers and researchers in higher education to actually, to investigate, teach, and publish their findings without interference or fear. That liberty, that freedom to know that, okay, what I'm going to present, there will be no interference, there will be no fear, there will be no retribution. And of course, for students to learn in an environment free of ideological coercion. Therefore, it's considered a cornerstone of higher education, essential for advancement of knowledge and robust democracy. So we realize that discussions on academic freedom are quite pertinent. But you see, there must be that freedom to feel that, okay, what I'm going to present will not be used against me. But also the liberty to debate, whereby you are able to debate on things freely without fear or favor. So that is the freedom which must be enjoyed by teachers, researchers, but also students in education institutions. Now, of course, there are certain components, there are certain embodiments, there are certain elements which constitute what we call academic freedom. First and foremost, academic freedom generally encompasses 4 interrelated elements. Freedom in the classroom to discuss all relevant matters within their subject area. Now, this does not, however, protect introduction of controversial, unrelated matter to the subject. So that implies that academic freedom means to discuss all relevant matters within a subject. Now, some of these may be a little controversial, but there must be that sort of, the teachers, the facilitators or the moderators must feel that, okay, I think I'll give this example and there will be no recourse. So it stretches a little bit far when we talk about academic freedom. But of course, number 2, there is also freedom to research, freedom in terms of research, that is in terms of exploring avenues of scholarship, but also publish results without censorship. Now, allow me just give illustrative examples here for context. Take a situation where, you are taking up a case and you are taking up a case where you are going to research on prostitution and why prostitution has maybe continued in spite of criminal law, which clearly prohibits the behavior. So you may find there are institutions which will tell you, well, that is research which we are not comfortable with, and they'll give you reasons, which may be based on their policy framework, on their funders, and so on and so forth. But now that, in one way, that is denying this particular researcher to give us information which relates to questions of academic freedom. Can you hear me? So in one or another, academic freedom does a big job in terms of enabling this researcher to effectively give us information in all disciplines. So the moment the researcher feels that, okay, if I talk about this topic, I'll get a disciplinary letter, I'll be summoned, I'll probably be cautioned, I'll get a warning from my institution. That is actually, in one or another, deterring academic freedom. So it will definitely hinder that particular person from being in position to venture into those areas of research, and will perhaps say, well, for purposes of maintaining my job, I'd rather not venture in that territory. So freedom in research to explore avenues of scholarship and publish results without censorship. And that last bit, results without censorship, means when someone has done their research, they must be able to say, okay, this is what I have found. When, for example, someone comes out and say they want probably to research about the judiciary, you see stress among lawyers, these are areas where there are institutions which will say, well, but maybe we are not comfortable. So there may also be what we call intramural speech. Intramural speech, this is the right to speak freely on matters of institutional policy or action without fear of administrative discipline. Now, of course, when we talk about matters of institutional policy, as we shall get to see, that is the institutions like institutions, probably even education institutions, universities. It could probably imply institutions like organs of the government, like maybe the executive, or you talk about maybe how the legislature is operating. So you look at issues of institutional policy, institutional culture, institutional organizational culture, and you are trying to deconstruct and revisit how they operate. You are trying to probably explore how they function. Now that implies the right to speak freely, even where the findings are against or are showing that this particular institution is a little bit messy, or even where the findings are showing that maybe, well, for example, if I'm to undertake a research on Law Society, but then you find that in my university, Law Society is one of the main funders or it's probably one of the key stakeholders. So the institution, whereby on every graduation, Law Society is always invited. So I make my investigation, and it shows that my findings are going to be a little negative on the institution. So the institution may give me, at times some institutions will give you a warning. So the administrative discipline, without fear of administrative discipline. Now, there are countries where that is enjoyed, but there are countries where we are still growing in this area, whereby someone has to think twice whether they should or whether they shouldn't do certain things. Okay? So now, of course, for students, it's important, apart from researchers and lecturers, but also I will mention that when we talk about academic freedom, in as much as we are talking about academic, it a little borders into law, because some of the people who are in academic, they may probably also be involved in practice. So you may find that sometimes even the cases, whether we can cite certain cases within when we are teaching students, So if, for example, I'm picking a case and the case relates to a vice chancellor, but it has very interesting administrative outcomes, So the question might be, am I, as a lecturer, going to freely use that case, especially where the institution still has ties with that vice chancellor, or a case relates to a DVC who probably went to court or something. So you may find that questions on the academic freedom are broad, and we cannot underestimate, especially when we are dealing with legal subjects. For students, academic freedom includes the right to learning, to a learning environment free from bias and indoctrination, but also the ability to inquire and evaluate ideas, and the freedom to express their views within education environment. So at the end of the day, the education environment gives us the bottom line, because there must be that liberty to feel that in an education environment which is free of any restriction, but also it must be free of any bias. So that means I may not agree with the student, but then that should not take away the liberty of the student maybe to express themselves or to even give me an opinion. Now, I'll give an example. There are particular people who strongly disagree with AI. So the moment they realize the student did research using AI, they already said, no, that must be a zero. This is total copying. So that means there is an implied bias as maybe an evaluator or as a facilitator or sometimes even as a judge. So we find that it's important because it enables freedom for students to actually have a conducive learning environment without any influences of whatsoever. Now, there is an interesting paradigm between academic freedom and freedom and free speech. While the two concepts are distinct, but we realize there are overlaps. Free speech, for example, as portrayed, I will borrow a little bit from the American jurisprudence. In the US, they talk about public institutions. It is premised in the quality and the status, but also the field of ideas, protecting virtual expressions under the law, protecting what someone has virtually spoken out. You see, in certain cases, we get a little bit outside merely what we talk about as academic freedom, but then we talk about expressions. People represent the expressions, and this stretches in another field of copyright into published works, literary works, into sculptures, into musical works. So realize that sometimes what people study in institutions can be translated into what they do in terms of copyrightable works. And we are aware that certain times when some books are published, but also when some exams, we shall see in my examples down there when I will narrow it to Uganda. Some exams have caused controversy, examination papers. I don't think I want to give those examples, but we shall get there. Now, protections of academic freedom globally. Now, different entities across the world or different institutions across the world, they have developed certain mechanisms, you see, but we shall probably get to see some of these mechanisms a little bit alien to our Ugandan setting. When we narrow down to Uganda, academic freedom is protected through various means. One, professional standards. For example, I think in the American approach, they have used institutions like the American Association of University Professors. You could look at like the Uganda Law Society. So these entities come out and they create what we call a widely adopted professional standard for our educations. And there will be a clause on protection of academic freedom. There will be a clause on emphasis of academic freedom. Now, this seems something which is not yet fully integrated in the way we operate in our country. So tenure is very key as well when we are looking at the layers or themes of protecting academic freedom. Tenure is key because it provides the faculty with a degree of economic security in the due process, but also ensuring that we can research and teach on controversial subjects without fear of dismissal due to political pressure or administrative shifts. Because now you realize that that means you can talk about questions of constitutional law. You can cite any case, even if it's probably not in favor of a particular individual. So you'll have that objectivity. You'll be able to assess things objectively, but also with a free mind. But in addition to that, law and contracts are very pertinent. Here is, again, I notice there is a lot of evolving students in the US context. When it comes to how academic freedom has been integrated as a constitutional value. Now, public institutions, of course, here institutions emboldened into their contracts elements of academic freedom, and they provide protection for it very specifically. Now, of course, now I delve into the international framework. You see, when we are talking these things legally, we don't want to talk as if we are simply having conversation. They are grounded, they are based, they are founded on certain legal principles internationally. So we have a legal framework on academic freedom internationally. So it's protected under the Universal Declaration on Human Rights. Article 27 protects the right to freedom from scientific progress, implying freedom necessary for scientific research. So there has been an interesting overlap when we are talking about the right to benefit from scientific progress. Because sometimes you may find the results which are coming from the research are not favorable, but you have to present the findings. So many times for societies to progress, such research is inevitable to show that, okay, we have an institution of the judiciary, but it's not performing well. But the results are showing it's not performing well because it's doing badly in terms of gender mainstreaming or in terms of gender equality. We have maybe, you carry out a study on how different institutions work, especially university institutions or other institutions or law schools, and you're trying to see how well are they performing in terms of allowing Ugandans with disabilities to study law or to be admitted or even become lawyers. So you begin with looking at how many lawyers maybe in the law society are classified as lawyers with disabilities. And from your findings, you tell us using figures and statistics and say, well, the number is quite, it raises questions. So now you realize that that is scientific progress where you are going to use facts and figures to show where policy, what we call a shift or a change in policy direction should be. So implying freedom is necessary for scientific research. We can't be able to carry out research. Sometimes some of this research, and I'm using the word scientific here figuratively, but I'm talking about any research where we're going to use methodology of maybe quantitative-based studies. And that research has done a lot in terms of guiding policy, but also in terms of changing and reforming practice. Of course, now again, we also have the International Convention on Civil and Political Rights, the ICCPR. Now, this one, of course, was it's an instrument of 1966, an international instrument, and we as Uganda, we are party to it. Now, we have Article 19 protects freedom of expression, including teaching and commentary by researchers. So that implies, you need to remember that when researchers are teaching and making commentary, they refer to cases, decided cases. They may refer to decisions of judges, quotations used by judges. But for that to happen, there must be a certain level of academic freedom. Now, safeguarding the right to be peaceful, to peaceful assembly and association is vital for academic freedom. So we realize that the earlier presenters may have talked about association, assembly, and so on and so forth. But we realize that sometimes there is an interesting correlation or collaboration between the rights to peaceful assembly and association when we are talking about also what we call academic environments. Now, we also have the International Convention on Civil and Political Rights, especially Article 13 and Article 15. These guarantee the right to education. But also we have got certain committees like the ECOSOC, what we call the Economic, Social and Cultural Rights Committee. It has made reference to academic freedom for staff and students. That committee has made specific reference to the academic freedom. Now you realize that academic freedom borders on two areas. One, the students, and on the other hand, the staff. We shall be very clear that, of course, even when we are talking about professionals, we lawyers, we've gone through, at some point we've been students, whether we like it or not. That's undeniably clear that we've been law students at some point in time. So that's why the liberty and freedom people to think freely without restriction is key. And that will be often manifested when, people are making submissions or professionals are making submissions because they have been grounded through what we call liberty and academic freedom. But of course, under Article 15, paragraph 3, it requires states to respect freedom, which is essential for scientific research and creativity. So we realize that for us to have creative minds for people to come up with what may seemingly look crazy ideas that eventually become important for change, we have to allow what we call academic freedom. Now, we also have other declarations or even other non-binding entities in terms of academic freedom. We have the UNESCO Declaration of 1970. This one I won't go into details, I'll just list them. We have the Kampala Declaration on Intellectual Freedom and Social Responsibility. We have Principles of 2021. We also have the Bonn Declaration of 2020. We have the Lima Declaration. Now, these are just declarations. They are not binding, but they are very persuasive. I would have preferred to go into the details of them, but time is way against me. Now, let me now narrow down. Part of my discussion is to look at academic freedom in Uganda. Where does it even come from? The constitutional background, the constitutional framework, what we call the legal history for academic freedom. It stems in the Constitution. And we have the Constitution, the 1995 Constitution of the Republic of Uganda guarantees the right to freedom of expression, primarily under Article 29, which explicitly, includes freedom of press and other media. However, this right is subject to limitations which are contained in Article 43. The earlier presenter has presented about limitations under Article 43. So I think here what we are looking at is what we call a delicate dance and balance between Article 29 on the left and Article 43 on the right. Now, what certainly happens is that sometimes there has been excessive emphasis on Article 43 to the detriment of Article 29. And that is why the questions of academic freedom become pertinent and important. Because sometimes you realize that not only lawyers, but also people in academia, they may write articles, and those articles may bite or may pain certain entities, or they may be a little bit problematic. And that is why academic freedom becomes very key. Of course, we may narrow down to look at the regulatory framework for higher education. You see, we can't talk about academic freedom, and we don't talk about institutions where these issues of those spaces or places where the academic freedom is supposed to manifest or thrive. So the institution framework for regulating higher institutions, we have the National Council for Higher Education, which is the statutory body responsible for overseeing, but also regulating the entire higher education sector in our country. And of course, it has functions here, which we cannot overlook. Okay, of course, one of them is regulation, guidance, accreditation, quality assurance, equating qualifications, advisory control. Be as it may, I'm more interested in the comment I'm making finally at the end of this slide, that the protection or even safeguarding academic freedom appears nowhere in the current mandate of the regulator, which is the National Council for Education. Of course, in my observation here, I realize that maybe the institutional framework should at least have some clear sort of a well-grounded responsibility by mandating somebody who is not only meant to regulate, but also to have some sort of a role to play in the event academic freedom is either steeped or even undermined or even underrated. So that's why here I give the institutional framework, but I notice that there is a gap. The institutional framework doesn't give room for who or is in charge of protecting academic freedom. But of course, the courts have done their role, which I've seen a few cases below. Now, gaps in protection of academic freedom, I have already highlighted. There are institutional gaps. Of course, in as much as the freedom of expression is guaranteed under the Constitution, freedom is often treated as related but distinct. Now, that leaves many vulnerable pressures, and I will highlight some of these. One, to begin with, there is what we call there is a lack of explicit legal provision. The Ugandan Constitution and the subsidiary laws lack express provisions which are specifically safeguarding academic freedom. Now, that makes it difficult to litigate violations effectively within the national legal framework. So that's the first constitutional criticism. We've seen Article 29. We have also seen Article 43. And I have said, because the Article 29 is a little bit vague, it's talking about freedom of speech, freedom of media. It's not specifically and expressly referring to academic freedom. Because you see, in as much as academic freedom talks about literary works, like publications, articles, examination, and so on and so forth, these may be slightly different when we are talking about media and journalism, which is an established profession. So there is still room and vagueness, and that vagueness has been used to the detriment of academic freedom. Perhaps that is a call for reform. Number two, there is also political interference. There are frequent reports of the government interference when it comes to affairs of public academic institutions, including the deployment of forces even in campuses where pressure related to political sensitive topics. Now, that obviously means academics often fear researching for speaking in terms of topics which can actually harm their career, but also their profession. So realize that because of academic freedom, there have been certain areas where political pressures may make some academics feel they are not comfortable to ever comment or discuss on certain topics because the topics are a bit sensitive. So someone may rather say, well, to safeguard my career, let me not venture into this area or even write about it because it's a sensitive area. So we realize that those are consequences of an environment where academic freedom is a little slippery. Then there is also institutional pressures. So university administrators sometimes may also actually also be, there may be cases where they may have dissenting views on certain issues. So as an academic, someone has to be a little cautious and a little careful when they are dealing with certain areas. So they may be a little bit selective on what they can talk about. When it comes to law schools, you may have to be selective on which cases you are going to cite. Even when you feel the case has some relevant points, you may be forced to say, well, let me avoid this case because it's a bit political, or because the case, you know that maybe there is a person who has a keen interest in it. So especially for us who are dealing in legal subjects, those are realities which we have to live with in terms of legal education and legal training. Now, of course, again, academic freedom raises questions of what we call self-censorship. Now, of course, due to the climate of fear and potential repercussions, there is self-censorship, which is reportedly widespread among staff and students who may avoid expressing opinions. And I have already talked about that. You have to do self-reflection and say, well, should I write this article? Should I publish these findings? Because again, if the findings get viral into social media today in this age, you've seen things being shared on forums like WhatsApp. It may raise questions on the author, and it may raise questions on your status and your position or your orientation in various fora. So some people may actually begin to conceal ideas, which we call self-censorship. Now, of course, the other element, this is more of a factor, is that, of course, when there are ratings or rankings of countries globally, when it comes to maybe academic freedoms. So I think what kind of happened is that for our index as a country, there was a slight decline. When I looked at available data statistics, we used to, in 2024, we had a 0.390 index out of 1. Now there was a slight decline to 0.5 index points according to the data. Varieties of when it looks to questions of the ratings, that is basically the extent to which people can expressly write on all topics without fear. Now, academic freedom is important because it's a foundational principle for advancement of knowledge, but also innovation. But when you also look at issues around protecting students to critically inquire about without fear of censorship or even retaliation. Now, there are just other few highlights of benefits or importances of advantage of academic freedom. You know, of course, it also has an advantage of advancement of knowledge, pursuit of knowledge. That implies people can venture in any areas and any topics. Someone wouldn't be scared to say, well, I'm going to research about cohabitation in Uganda. Is it even there? Okay, if it's there, why is it on an increase or it's on a decline? And where do people in cohabiting relations fit in terms of access to justice in family division? So the question which may seem morally problematic, because if you are now working with an institution which is attached to a church foundation, these are areas which may be a little tricky. I don't know whether they may even fund you. So limiting academic freedom may even limiting access to funding from certain institutions on particular topics. Okay, so also pursuit of truth. Academic freedom allows scholars to investigate and discuss challenging and unpopular ideas, but also question established norms and publish their findings without interference, which is essential for what we call free search for truth. So if we need to know whether we have a big number of Ugandans cohabiting, that is a question we need to investigate. And someone may be, willing to receive resources to investigate it, but there are institutions which may give you, which may not be comfortable with that because it's research which is a little morally questionable and religiously problematic. Of course, when you allow academic freedom, you are giving room for innovation and progress. Freedom to conduct curiosity, but also driven research. Curiosity-driven research can eventually give us what we call intellectual risks and breakthrough in science, technology, medicine, humanities, but also social science, studies have actually shown a strong positive link between high levels of academic freedom and increased innovation. So the moment you allow academic freedom, on the other side, there will be increased innovation. The two seem to work hand in hand with each other because you are giving people to think outside the box. You are giving people to think what is possible. And you are giving people to, through that thinking or ideas, people will be able to innovate, or the society is able to innovate. So the more we create a free space for academic freedom, the higher that our research will actually regenerate practical and realistic benefits to society. But of course, the other advantage is what we call the diverse perspective. Academic freedom ensures diverse perspectives and approaches within academic community. Now, this enriches collaboration and quality of research when it comes to education. So that is basically, you will allow people with different opinions, people who are writing in support of different stands or different opinions, different views. So that is basically what we call diversity perspectives. There are people who may agree, and we've seen this even in judgments. There will be judges who agree with a certain position, and others have dissenting opinion. That is called diversity of verdicts or views on the when we are looking at the decisions at the bench. So that kind of diversity can only happen if you give room for what we call academic freedom within the setting of the research institutions. Now, for education and students to succeed, academic freedom fosters thinking. This is basically where academic freedom creates safe spaces for students to explore every perspective of the topic. They will leave no stone unturned because they will feel, okay, they are investigating, they're having an inquisitorial approach in everything you're giving to them without telling them that, okay, you can't read on this topic because this topic is religiously questionable or it raises certain. So that is the benefit, fosters critical thinking. It takes away the mainstream-based approach and says this is the only right way to go. So people, students, but also communities will be able to at least look at something with a comprehensive eye. It also enables engaging relevant curricula. It empowers faculties or entities in education to use their professional judgment and expertise to design relevant course content which meets students' needs and interests. So it enables at least to do a critical reflection on what is being taught. Why is it being taught? What results will it deliver? Does it resonate to society? Does it, do the products of institutions eventually have any practical benefits? What sort of research is being given? Now that can only happen when we engage the curriculum with what we call, with a mindset of academic freedom, but also a safe environment for expression. A climate of academic freedom helps to support mental health and well-being of students by actually creating an environment where they feel safe to express themselves and their diverse background, but also their experiences will be valued. So a student will not be worried because they wouldn't be probably pointed out because maybe they seem to align to a certain political ideology or to align to a particular religious ideology, even in an institution which has what we call a dominant, what we call a mainstream or majority approach to certain things. So the safe environment where everyone is, people will be allowed to carry out their view. I give an example. If someone is going to carry out research and they are going to carry out research on, I gave an early example, someone is researching on prostitution, in Uganda. But then you may find someone trying to research on LGBT rights in Uganda and is trying, probably keenly interested to know, how are doctors handling these people, these patients? Are they there? So and you may find that is a topic which raises serious moral but also criminal considerations. Now, if there is an academic freedom, you can't research on such a topic. You are a researcher, you are not involved in the behavior, and what your research will help us to get to understand, okay, is the law working? Oh, okay, fine, it's working, but is it working well? Why is the behavior still manifested? What can be done to make the law function better? But again, colleagues, when I talk about this topic without giving classic instances where academic freedom has gone into courtrooms and corridors of judicial justice, I think I'll be doing injustice to this question. And therefore, these are just a snippet and an example of a few. There is a case of David Kitara Longolo versus Gulu University. I don't think I'll go into the facts. A judgment of Justice Stephen Muvidu, and I think it talks about pronouncement on the scope of academic freedom. This case is readily available online. You can read it. a very interesting case. It raises the curves, the ups and downs, the valleys and the mountains around academic freedom in our country. Now, of course, there is also another one, the case of Fox Odoi and 20 others that on a constitutional petition, 23. Well, it is exclusive, in as much as this case is not specifically on academic freedom, the legal commenters and the scholars at Makerere University have actually made very interesting commentary on the constitutional's decision. The court may have failed to robustly protect freedom of expression, thereby creating conditions where academic freedom is implicitly eroded. So I mentioned earlier that freedom of expression and academic freedom, they are distinct, but they are two related brothers. They may not be identical brothers, but they are we can look at them as fraternal twins. They are interconnected because free speech will normally give a wider forum or a wider platform for academic freedom. Now, we also have, of course, Makerere University and student disputes. There are several internal university conflicts that have led to some legal interdisciplinary areas. So a few examples you may have followed, you may have observed this Dr. Stella Nyanzi's case, had dismissal from the university, and the subsequent legal battles on sexual harassment. There is also the examination question controversy in 2024, an incident where Makerere University School of Law got involved, an examination paper that included questions referring to particular political figures and events. The paper triggered an investigation. So you realize at the beginning of my discussion, I said, when you talk about academic freedom, it may even relate to an exam you've set. An exam you are setting, and you may have to trigger serious consequences. Now, this is real because it has happened to a particular paper. So that definitely means as the law lecturers set the exams, then they need to pause a little bit back and say, wait a minute, won't this cause me challenges? Do I still have a safety from job tenure and so on and so forth? But I should mention that there are countries where such fears will not arise. Now, of course, again, the problematic, on the other hand, it would be wrong for me to have a one-sided analysis. It's only fair and right to talk about the other side of the coin. And it's important for me to mention that there is a problematic side where there is unlimited academic freedom. Okay, so if we look at the unlimited academic freedom, it's problematic because it can lead to abuse of power and, of course, lead to disciplinary incompetence. This is the last part of my presentation, and indoctrination, but also it can lead to a decline in academic integrity. Now, instead of absolute right to academic freedom, it is understood as a professional right balanced by significant responsibilities and a system of peer accountability. So it's important that in as much as we may push for academic freedom, we must put safeguards in place to ensure that it's not abused. So potential for abuse of power. One of them could be indoctrination of students. The unchecked professor might use their position or authority to promote a personal political agenda or a specific ideology rather than to foster critical thinking and explore diverse ideas. So students who are inherently in unequal power, so that implies they are dependent on this professor. They will take what this professor says as a Bible truth to the detriment of critical thinking. And actually, sometimes that is where there is a thin boundary between indoctrination and educating somebody to impose ideas or even sometimes promote radical views. So there is also disciplinary incompetency. This has two areas, lowered standards. Academic freedom is not a shield for incompetency without peer review or collective judgments regarding what constitutes valid knowledge. When we're looking at what is being taught and information, is it factually correct in the first place? Is it based on what we call pseudoscience? Or does it hinder pursuit of truth and progression of knowledge? We need to first of all reflect, because when you are talking about academic freedom, on the other hand, you must be talking about correct information, not misleading or inaccurate information or untrue facts for that matter. But of course, on the other hand, there is the irrelevant content. An individual might introduce controversial material that has no relation to the subject of the course, and that obviously has an effect of detracting from educational purpose and potentially wasting students' time and tuition. So because someone has a radical opinion on a certain concept, they diverse, they go off a tangent, and they begin talking about something which is not relevant. So when we talk about academic freedom, we should remain guided by the syllabus. If you are talking about contract, then let it remain contract. Even if you are bringing in some discussions on academic freedom and critiquing how contract law in Uganda works, you need to remain on course. You need to remain talking about offer acceptance and consideration and other guiding principles, not to bring in something which does not in any way relate to the syllabus of the topic, so that your content remains of relevance to the students. Now that marks the end of my presentation. Thank you very much. I'll be very happy to receive any questions, and I'll be very happy to respond to them. Thank you very much. I think I'm going to stop screen sharing.
Okay. Thank you very much, Mr. Mugabe Ivan Kayiti, for the wonderful presentation. Members online, if you have any questions that you think Mr. Mugabe should address to, please feel free to post it in the comment section so he can answer the questions. I hope we are paying attention to the discussions. I am aware that right now we're in a scramble for points, but I hope we keep the conversations. We are active in the conversations, yeah? As we wait for your comments and questions, we are running out of time, and it's right that we move to the next speaker. On the next session, we have the exploring the right to food, the law, practice, and call for immediate action. And we'll be taken through this session by Dr. David Kabanda, who is joining us online. Dr. David, can you hear us? Dr. David Kabanda, can you hear us? I can see you online. Okay. As he's preparing for his session, just a bit about our next presenter. Dr. David Kabanda is a food and health rights legal researcher and lawyer with special interest in social justice and food trade-related systems. He practices through legal research, advocacy, community legal empowerment, public interest litigation, legal research, and invoking social equity and the doctrine of public trust. He is an expert in food law, an advisor in sustainable agri-food systems, and promoting safe food environment. He has done consultancies with UN FAO, United Nations High Commissions for Human Rights, World Health Organizations, and UNESCO. He has implemented projects supported by SIDA, UNDP, SDC, OSF, Helwet Foundation, and Aves Foundation. He is a food law PhD graduate from the University of Western Cape. He has pioneered the litigation on the right to food and health in Uganda and East Africa, especially maternal health. He has now pioneered the right to food, justiciability, and realization in Uganda, East Africa, and Africa generally, contributing to the growth of jurisprudence in this area. Dr. David Kabanda has founded a social rights organization, including the Center for Health, Human Rights and Development, CEHAD, and now the Center for Food and Adequate Living Rights, CEFAT. He serves on several CSO's board and a lecturer in Kumba University School of Law and Chambogo University Faculty of Food Technology and Nutrition. His career is devoted to social inclusion and accountability using human rights approaches. He has had tremendous contributions in law, policy development in social rights for food and health. Dr. David Kabanda is leading a team of lawyers in East Africa and in Uganda under the Agriculture and Food Law Cluster in the Uganda Law Society. He has led several human rights campaigns, including the right to food, right to livelihood, maternal health, access to medicines, right to a clean and healthy environment, right to a smoke-free environment, access to utilities in hospitals, mental health, and access to information to ensure accountability from duty bearers. Dr. David Kabanda is a founder and currently the executive director at Center for Food and Adequate Living Rights, CEFOT. Ladies and gentlemen, join me in welcoming Dr. David Kabanda in discussing this very important topic that touches and impacts health, dignity, and life. Dr. David Kabanda, you're welcome. Yes, we can.
Happy that I'm going to be speaking to colleagues about this fundamental right called the right to adequate food. I want to start with a very disturbing statement that for a very long time, humanity, particularly in Africa, has not understood this as a legal concept at all, because we think that food is a given and it does not have anything to do with limitations and or enforcement. But before we dig into the law, today as I speak to lawyers, I know some of us, I have just heard the commentator say that yes, we want the CLE points, but at least let me use this opportunity to cause some awareness to all of us about this very important sector of food and maybe also agriculture, not only as a legal concept or a career concept someone can pick on, but also as a legacy building theme or thematic area. So today, as I speak to you, remember what you ate in the morning, and maybe you can also ponder about what you'll eat today for lunch and maybe evening. And also, if you have children, think about your children. Many of them are back in school, from school, and they're at home. So what are they eating, and who provided what they are eating? Where did you get it from? Did you buy it or someone gave it to you? What do you have in your house, or what are you planning to buy? Are you actually buying food or a cancer-causing product? Because that is also very possible. So having said that, ladies and gentlemen, we have this animal called the right to adequate food. What does it mean? It means it is a description that we can understand from this statement. It is fulfilled when everyone has a right to a standard of living adequate for the health and well-being of himself and his family, including food. So when you go to the Universal Declaration of Human Rights, Article 25, that's where we start from. Way back in 1948, globally, as humanity, we agreed that everyone has a right to a standard of living adequate for the health and well-being of himself and his family. And this includes food. And some of us, when we talk about everyone has a right to a standard of living adequate for health and well-being, lawyers are the first to run out and say, that doesn't concern us. We get a lot of money. We are a prestigious lot. Little do they know that sometimes what they eat, actually a person who has never even gone to school can even be better. So we are going to be unpacking this the right to adequate food is a fundamental right because every one of you is a function of food. The sperm and the egg that brought you into being its foundation was food. The body picked nutrients from a matter that was served to eat, and it used those nutrients to come up with molecules with all the settings of the body to form who you are. So it is a function of food. So the right ensures adequacy, availability. I'll be going to this, and I'll be looking at the international. I'll not take a lot of time at the international legal framework, but we'll also take some time on the state obligations, challenges, and recommendations. So the right to adequate food is realized, and this is very important. It's realized when every woman, every man, every child, whether alone or in community with others, have physical and economic access at all times to adequate food or means for its procurement. This description sounds like a mouthful, but each word in it has and carries a lot of meaning. For example, when the description talks about every man, because the nutritional needs of a man are diametrically different from the child and from the woman. A woman who is going to conceive, that they prepare themselves 6 months before, and the diet must change such that the body can prepare for the child. Same thing with the child, same thing with the man. Our functionality, including the brain, including the senses, including all the vital organs, including our bone and structure, muscle structure, our capabilities are hinged on the kind of food we eat, how we eat it, when we eat it, and which kind of social setup. And this is the bedrock of why law is very, very important for this thing that for a long time we have neglected. Yet, everyone who wakes up, the first thing they think about will be food, or if it is not themselves, then how their people will feed. So the right to have regular, permanent, and free access, directly or by means of financial purchases, to quantitatively and qualitatively. And this is very important because many people have what they call food in big amounts, yet in actual sense, what they put in their body is not food by the technical meaning of that word. So the right to food guarantees the right of people to a quality that is sufficient to satisfy their dietary needs. This food or something that you eat must be free from adverse substances and acceptable within a given culture. So you don't go to a Muslim community and start frying pork. You'll have caused problems. There are cultures that don't even eat fish or something like that. So food requires that one, it is safe from any contaminants, safe from chemicals, safe from pathogens that can cause illness or death, and it must also be culturally appropriate. So let us look at the elements. One of the cardinal elements of the right to adequate food, if you are talking about food, because you remember in the description that I've made above, we are talking about every man, every woman, every child has access to food alone or in community with others. The access can be physical, meaning that the food is available, or the food can be accessed through buying it. So when you look at all these, we start with availability. The food must be available. Whether the people have gardens, and it also has a lot of legal, ramifications. And two, all people can buy lawyers. We have statistics from the Uganda National Bureau of Statistics indicating that on average, every Ugandan's income, 54% of their income is spent on food. Maybe you are subconscious about it. Maybe you've never taken time, and that is the average, meaning that the percentage could be higher for some individuals. You go back and look at the money you've been spending. What have you been spending that money onto? So, availability of food. If in your house today, dear lawyers, what is available is, in fact, some of you, because now I'm speaking to us in our circle here as lawyers, you may find that you do not have the capacity right now to determine with certainty the amount of food that will be in your house for 30 days. Maybe I'm even putting it too high. Some people don't even know what their people and them, the availability of food for a week. So, and this is a cardinal element. So if we are talking about food, people must be certain of the availability of food, whether from their gardens or from their social networks or from the market. So when the food is being traded, the government is not supposed to fold their arms, because this is not only a function of supply and demand, or demand and supply, because the food must be available. People must be able to see the food. Then the second cardinal element is accessibility, because food might be plenty in Kabera Maido and it is scarce in Adjuman. So accessibility, food must be both economically affordable and physically accessible. So when we are talking about the right to food, accessibility, do people have the power to buy the food they need? Okay, the food may be available, but is it accessible? Because not every available food is accessible to people. It could be a lot of food available. Some people call Uganda a basket. But we also have statistics of Ugandans who are suffering from anemia, women of reproductive age, to a tune of 29%. Are malnourished. They don't have even enough blood because they are not feeding well, meaning that the food, although may be available, but it's not accessible. We have children who are malnourished, who are suffering hunger, to a tune of 40% Ugandans who are in some form of hunger. Many Ugandans cannot afford the 3 meals in a day. What they can afford, it could be 1 meal, and then for other meals, they can play around. And then we have 11% of Ugandans who are suffering right now acute, meaning that they cannot even afford a meal a day. So the third element from accessibility is adequacy. And when we are talking about adequacy, we are not talking about the quantities, although that is also very important. Food must meet dietary needs based on factors like age, sex, health, and occupation. If some people are involved in hard labor, then the kind of food they should be eating should be different, because it must have enough calories to sustain the energy requirements. The food must be nutritious, safe from contaminants, and culturally acceptable. Now, this is why I started with a statement, dear lawyers, that look back in your home, wherever you came from. First, answer this question. Did you leave food there, or you don't care about it? Okay, if you left food there, how long will it take your people? Okay, is it a week? Is it a month? Any household that does not determine its food from an annual basis, it is already an indicator that the right to adequate food in that family is being violated. And this is why at some point I even said some parents in Uganda must be sued, because in their households on a daily basis, when they don't violate the rights directly, at least for their children or even the dependents, they threaten these rights, particularly the fundamental right to adequate food. Then, after that, where did you buy this food and what kind of food is it? Because, ladies and gentlemen, it is very unfortunate that I'm speaking to you, and maybe as lawyers, we need to see this as a very big legal opportunity or career path that we can do in Uganda, because we have now suffered what we call a nutrition transition from what used to be unprocessed food now to processed products. You may tell me that, no, Kabanda, what you're talking about is gibberish. I went to the restaurant and what I ate was matoke, maybe my kaloma, but you ate sauce and it was so delicious on your tongue. But do you know the spices that were used? Do we have a law in Uganda that requires all restaurants and hotels to tell us the ingredients of what they put in that fish that they have served you as stew, as fish stew or goat stew, or even groundnuts? You all know that in Uganda it is the deadliest place in the world to eat groundnuts, because they are contaminated with aflatoxins. Secondly, when you go to the milling place, the biggest in Uganda, which is Kisenyi, you'll be shocked to find that they replace machines, and the groundnuts that you ate or you are planning to eat today, if you did not do it at your home, be sure you are eating metal in what you call sauce. There is metal. And this is why some time back, the president, on addressing the nation, also talked about it. But although he said that a presidential directive is going to come out, we have demanded for this, it has not come. It has not yet come. We have also, I'm still addressing this critical element of the right to adequate food called adequacy. We have a report from Makerere University School of Public Health indicating that 89% of the food in the main markets, they did research in 18 districts in Uganda, is contaminated with cancer-causing agrochemicals, synthetic chemicals, many of which have been banned in other countries, including Europe and the US, but some technocrats in the Ministry of Agriculture in Uganda issue import licenses, and those chemicals are in Uganda. One of it, ladies and gentlemen, dear lawyers, if in Uganda you eat tomatoes that you don't know where they came from, maybe you stop it. because anytime you've seen tomatoes having that whitish substance, it is a cancer-causing chemical called mancozeb, very effective on preventing blight and fungal disease, but it is too dangerous. It causes cancer, it causes infertility in women, it causes DNA issues, it causes all sorts of morbidities and mortalities. And from Europe and everywhere, it has been banned. So as we go out to eat, as we go to the market to buy, lawyers must not be seen to join the human rights violators. So the critical element called adequacy requires that the food must be nutritious and it must be safe. Another element, maybe which I didn't put here, is sustainability. Are we producing the food sustainably? We have people who cut down forests to produce maize. We have people who are spreading the gospel of monocultures. We have people who do not care about the bees. The bees are dying at a terrific speed in Africa because of spraying. We have people who do not care about the soil. The soil is a living thing, but who must manage? The government has not put in place efficient structures of agricultural extension workers. Now, what happens is that the general population, including lawyers, fortunately or unfortunately, even the government officials up to the level of ministers who have refused to do what they ought to do, end up into non-communicable diseases, which are dietary related. The only thing that they again take our money and they go for medical tourism in India, in the USA. Now, you, an ordinary Ugandan, at least Betty Kamya told us, we do not have that, we don't have that luxury. So we end up in 2 car wash drives, we end up depleting all our hard-earned, properties, and we sell them because a particular individual in your family has cancer or has diabetes. Many people's legs have been amputated. Many people are working with diabetes drugs. Many people cannot perform properly anymore because everything is being sprayed. The soil has been degraded because of the farming systems. And we cannot run away from farmers. We are lawyers, but we come from farming families. We are lawyers, but we know that many of us are farmers, meaning that we are into that deep structure because Uganda is an agrarian country. Maybe we should come up as Uganda Law Society and say enough is enough. There must be a gate policy at the market. Many of you are going to be buying chicken, but do you know the kind of chemicals that were injected in those broilers, the 4 weeks, kio that people eat? As you go to the market, as you shop for Christmas, do you care about the expiry date? Do you care about the water that you are taking to your people? Do you care about the microplastics? I'm not sounding like I'm an alarmist, but these are facts. So as we look at human rights, sometimes lawyers just jump to the civil and political rights, maybe people who have beaten others, maybe people who have killed others, and those are sometimes the only things that we look at. But even you in your home, if people have spent the entire day hungry, it is inhuman and degrading. That is Article 24 of the Constitution. So when we are looking at these, let me quickly go to the obligations of the state. The state must respect, the state must protect, the state must fulfill the right to adequate food. They must respect it, limiting state power not to interfere in people's livelihoods. But they must protect, because like I have told you, that we have entered into what we call nutrition transition. Unfortunately, that many of what we eat right now is not produced in our nearby communities. You are eating wheat from Russia, wheat from Ukraine. Uganda right now is a net food importer. We are eating chapati, but who is getting the money? It is the Ukrainian, it's the Russian, it's maybe the Egyptian, it's not Ugandan food. So there has happened a nutrition transition, meaning that we have too many people who are producing food. The rice you eat today, many of you know, is from Pakistan, from what, and you'll also go for that. I want, there's this long grain one. So there's that village mentality and arrivalism that you see because you are in middle class. So eating junk is looked at if you are someone has attained some level in life. And many of the people, unfortunately, you see them, you know, high-end restaurants, maybe in Kampala, eating junk. They even take selfies and post them. And you realize that someone is committing a grave human rights violation to themselves, but also to the children, most importantly. So there is a lot of middle people in the value chain who engineer food intentionally. Some of the spices that are being used in the preparation of food, you know those spices, they advertise them, but they are lethal. Many of them are laced with addictive, cancer-causing ingredients, including the sodium glutamate that knocks your brain function of satiety. As a human being, God designed a body to when they reach, when you eat and you get full, when you get satisfied, what we call satiety, there is a body function that will trigger off eating. Now, what the food industry does, they put in your food, those high-end restaurants, these franchises. Some people eat chicken. You think that you are eating chicken. You are no longer eating chicken. They call it chicken because they need to appeal to your dopamine. They have to appeal to your sensory nerves, eyes, and everything. But it is no longer chicken because it has now been taken through a processing, ultra-processed process that right now what you are eating is an industry product disguised as chicken. The chicken that they got has now been taken over. These people are human rights violators. Only that lawyers have not woken up, but they are also part of the game. So the state, under international law, when you look at Article 25, I've already mentioned this. We also have Article 11 of the International Covenant on Economic, Social, Cultural Rights, which is very clear. Partner states under the UN, including Uganda, agreed that everyone has a right to an adequate standard of living, including adequate food. All the things that have been explained, ladies and gentlemen. So we have the Convention on the Rights of the Child. For me, sometimes I even say, if an adult has decided to commit suicide by eating themselves to the grave, maybe we should ask God that that process is accelerated such that they go. But when it comes to children, I have not only a moral obligation, but a legal duty to protect the children, including protecting them from their parents. Every parent who has an obese child they not only deserve to be in Luzira prison, but they must also be, the government must put heavy fines and to contribute to rehabilitation and making sure that the children, you see, some parents are feeding children as if they are feeding pigs, and they are feeding them on junk, violating Article 24 of the Covenant on the Rights of the Child. So all these international laws are very clear on nutrition as a legal concept, as a legal doctrine, and also on food generally, food security and food sovereignty. Unfortunately, lawyers have not yet understood that this is their work as well. Dear lawyers, we have companies, the Monsantos, the Bayers, who are pushing chemicals here, including seeds that are making our farmers, our smallholder parents and relatives in the villages, they are now being pushed into abject poverty, not by any other thing, but by the seeds that they bought last season. They give them seeds that cannot germinate the next season. It is us as lawyers to question this, to question the kind of slavery, and to also question the kind of human rights violations that are happening. I'm very happy I'm speaking in commemoration, and I'm speaking under the Human Rights Conference of the Uganda Law Society, and I'm speaking to colleagues, lawyers. We have our 1995 Constitution. If I started with Objective 14, if you can see my screen, Objective 22, the state must ensure balanced development of all regions and effective storage, marketing, and distribution of food. The state must protect natural resources, and including the environment, including biodiversity. Here we are all talking about food and agroecology. Unfortunately, even the judges have not yet realized, and many of them are also, I don't want to say sick, but it doesn't take me to be a medical doctor to tell that someone is gasping for breath. Many people are sitting with time-bomb illnesses, including diabetes, high blood pressure, because they are eating cakes. Who told Ugandans that every day you celebrate a birthday, you must cut a cake and eat like there is no tomorrow? Okay, if you want to eat, that would be okay. But do you know the ingredients that they use to make that cake? Do you know why it is too fine? Because it is heavily processed. All the fiber that naturally is supposed to uphold your body functions has been taken away through an industrial process. Many people, including grown-up lawyers, you'll find them eating icing sugar. People go to functions and they drink all sorts of soda, but the food industry has engineered these products to hook you up. In cakes, bread, donuts, mandazi, there is a cancer-causing element called the trans fatty acids. If you are eating margarine today, stop it. Because there is that ITFAs, they are called industrially trans fatty acids. What happens? The industry gets good oil, for example, seed oil, but because it is melting, they take it through an industrial process called hydrogenation, such that it forms into a solid margarine at room temperature. Anytime you see fat that is solid at room temperature, run away very fast. Don't use it. And all the confectionery business in Uganda is using it. Some of it is even on black market. And it is in bread. Today, if you are going to eat bread, because there is another issue of sugar. But fat, if you want to guard your heart, if you don't want to get what we call cardiovascular diseases, the diseases of the heart, the diseases, the cardio, meaning that it is related with the heart, high blood pressure, seizures, all those, including the vessel, because these industrially produced trans fatty acids have the elements of clogging your arteries and the blood does not move properly. It is all food related. French fries everywhere we are eating them from. Now, Article 20 of the Constitution is very clear, Chapter 4 actually. The rights of every individual, including the right to food, is inherent and must be respected, upheld, and promoted by all organs of government and by all persons, including you, including the restaurants. We need to even sue owners of restaurants, owners of hotels where we eat food from. If you cannot label, don't sell it. If it is not labeled, dear lawyers, don't eat it because a lot has been hidden in there. If it is not labeled, it is not safe. And if it is not safe, it is not food. Article 21, Article 22, which talks about life, Article 24, freedom from cruel, inhuman, and degrading treatment. Anyone who serves food that is unhealthy, food that is not worth to be eaten by human beings, has subjected to that human being, including parents, subjecting to their children to inhuman treatment. Because what you are giving them to eat, is not for human. So it is inhuman. And you are violating Article 24 of our Constitution. Article 39, talking about the right to a clean and healthy environment. Why should farmers in Uganda be allowed to use synthetic chemicals that are killing us? They are killing ecosystem. They are killing all the insects and the earthworms that are giving soil health and life. And then we are inhaling because there is an open cultivation in Uganda. If you have a neighbor and they are spraying, be sure that you are eating the chemicals through. So Article 45, Article 8A, we all know this as lawyers, but I wanted to make an explanation about Article 33. When you read Article 33, it talks about government or the state to respect the rights of women, including adequate nutrition. But Article 33.3 requires government to respect women, taking into account their natural maternal function in society, their unique status. That is what is written in the Constitution. The unique status of women and their natural maternal function in society. The natural maternal function in society is squarely a function of food. Because when you are talking about the natural maternal function in society, where does it start from? It means that as you take care of a girl child, you must be very sensitive about what they eat, because you must make sure that by the time they become mothers, they have the capacity to manage pregnancy and related complications. They'll be losing blood on a monthly basis. This is why girl adolescents must be fed differently. So if you are not feeding women well, right now, women in the reproductive age in Uganda, 29% of them are anemic because they are malnourished. When they are pregnant, because now there is another person coming up, the kind of nutrition must change. And under Objective 22, the government must create massive awareness of nutrition. But it doesn't happen. When they give birth, the function of food should be there because they must breastfeed immediately and exclusively without adding any other food to the baby. So Article 33.3 in Uganda is being violated on a daily basis from the state, that has not done its obligation, protect, respect, and fulfill, but also from individuals, including husbands, including caregivers, but maybe also women. Then Article 34, the rights of the children, let me not overmake this point, I've already made it. Then Article 36, Article 38, the right to participate, and also the duty of parliament. So when we look at the statutes, it is again very sad that, and I'm sorry to sound like I'm too much of talking about the negatives, but I have no choice. It is a fact. Right now, we do not have a framework law on food in Uganda. What we have is the Food and Drugs Act of 1959, a pre-colonial law, which is just having 2-3 sections talking about presenting unhealthy food or adulterated milk. And that's the only thing. But you see, from 1959 up to today, too many things have changed. We have a nutrition transition. We have too many players. We have too many non-alcoholic beverage, sugar sweetened, non-sugar sweeteners. There is too much science and trade and manufacturing and industrial processes that have now come into food. You've heard that Nestle is bringing all these baby foods in Africa, and they add too much sugar, which they don't do in Europe. It must be the function of the law to make sure that we can speak and be able to hold these people accountable. But in the absence of a good law or a framework law, this is impossible. What does it mean? It means that you as a parent or as a Ugandan, you'll continue having children who are weaklings, children who cannot function in class, children who are ever sick. Many parents are in and out of hospital almost on a daily basis. See this pediatrician, see this practitioner. A lot of money is being spent in the hospitals because the function of food in our homes and in our communities and also at government level has largely been neglected, ignored, and the government has refused to do or give us a framework law. Up to now, we don't even have a policy. They promised to give it to us this year by June. Up to today, Ministry of Agriculture, they haven't. And sometimes when we make such statements, the government thinks that we are calling them out. And that is unfortunate. So for when you look at the legal and the statutes in Uganda, of course, we have some other, laws that maybe talk about different segments in agriculture, Public Health Act, but that is not what we are talking about. Because when you read the Public Health Act, it is only talking about food should be stored, the store for food should be ventilated, things like that. But that's not what we want. We are talking about a food systems approach from the farm to the fork. Or the in-between value chains and players must all be regulated, and we must see a chronological flow from farm to the fork, which is not happening in Uganda. So the right to food is not a right to be fed. This is not what we are talking about. We are talking about the government's role to create an enabling framework where people can feed themselves with dignity, feed themselves and their families and their loved ones and their communities with dignity. It should be the government to create a legal framework that the synthetic chemicals are not finding themselves into our food system. The restaurants, we are going into the festive season. You'll see how people eat junk, how people are just eating death in small bits, chronologically. And then before they know it, 70% of the children in Uganda have ulcers. And what people think is ulcers, it is soon degenerating into stomach cancers. You go back and examine, parents can stand witness. At least in each household, you'll find children crying of stomach ulcers. Where did the children get the stomach ulcers? Children have diabetes. Children have hypertensive disorders. Where did these children get all this? It is because largely the right to adequate food has either been neglected to be realized or blatantly and intentionally being violated not only by the food industry, but parents have joined and the government is not concerned. So we don't want the government to think or to even divert the conversation to say, those food rights advocates are saying that we should feed people. We can't do that. That's not what we are talking about. What recommendations are we talking about? We think that a food approach system must be, a food systems approach must be the way to go. We want to ask you lawyers to join us to make sure that we cause a deep demand on the government to give us laws and policies, and then they should be implemented and enhance public participation and international cooperation. So a food system, I've already explained this, and maybe you've understood now. Don't look at food as a market object. No, food is social. Food is economical. Food is political, by the way. Many governments have been put down because of food. What happened in Sudan? It was bread. And maybe in Uganda here, we still have a chance that, because in Uganda, you can enter anyone's house and eat. Maybe this is why politicians don't care about us. People can afford to eat their junk here and there. So we really need to make sure that the production of food, the processing of food, the distribution of food, including transportation. Ladies and gentlemen, have you seen how the beef you eat in Kampala, particularly, how the cows get transported? Some of them, by the time they reach the slaughtering house, have even died. They tie their tails and they cause too much pain. This is a live, it is a living thing. And science indicates that the more it is tortured, it releases chemicals in its body. By the time you eat that meat, the meat is not safe and it's not supposed to be eaten. But why should government continue to allow that? If there are too many cows in Western Uganda or in Northern Uganda, why shouldn't we establish slaughtering houses there? And maybe what we transport is food in the food grade vehicles that are refrigerated, for example. You have seen how the vegetables are exported to your markets. They are no longer my markets. Me, I don't eat from those markets. Karerwe, Sujui, where I don't. Guys transport your vegetables, the nakati you eat. Sometimes they even pee in those things. And you have also seen what people eat on the streets as what we call street food. The flying pan is not food grade. It was a building material. They picked steel from a hardware and then they turned it into a flying pan. Who told people that every metal can be used to fly the food that you'll eat? So the street food is not regulated. Retail and marketing, waste management, consumption, all this must be based from a rights-based legal approach. The local governments must be put on tenterhooks, because every food outlet, every restaurant, those roadside, street vendors pay licenses. But the local governments only stop at getting the licenses. They don't go an extra mile to check on the public health, to stop them from using building materials as flying pans, to stop them from using used oils, to stop them from using all kinds of food additives which are synthetic in nature. We have not seen any given, and you people don't be misled to think that it is Uganda National Bureau of Standards. No, Uganda National Bureau of Standards is not supposed to look at nutrition issues. For it is just standards. Okay. We have done some work. All is not in vain. We have at least gone to court, and court has declared that the right to adequate food is a right for all Ugandans. At least the Center for Food and Adequate Living Rights have gone to court over that. And we have other cases from South Africa. I may not so much go into this because at least for them, they are ahead of us. They understand the right food. Maybe it's because the right food is also a substantive article in their constitution, including Kenya. In Kenya here, as our neighbor, an individual took Coca-Cola to court. They took Coca-Cola to court up to the Supreme Court level and they won. An individual like this. So we want to encourage, we have other cases from India. Litigation is the only avenue now that we see because we are speaking to government, they are paying a deaf ear. So it's very difficult. There are many challenges, weak policy implementation, limited public awareness, inequalities, and the forces of the market. Like I have told you, everyone is now looking at food as a market. Even when you go to agriculture or when you go to a parish development model, they are telling people, go to agriculture, have poultry, have piggery, have fish. Do you know how the fish in those ponds is raised? Then do you know the kind of milk that you are taking? Do you know that many farmers inject cows with, of course, to treat them? And then there is a window, you after injecting, then you must not eat or drink the milk, maybe for a week. But the milk finds itself on the what? On the market. We do not have the milk sector in Uganda for a Ugandan is not regulated. Because after milking my cow, I just go to the market and I sell. But who has made sure that the milk that I'm taking is not contaminated? The people who love pork, people inject and they are giving. You saw a report from Makele that indicated that ARVs are being fed on pigs and also on poultry. So these are some of the issues that we are talking about, and we are calling upon lawyers because it takes law. It takes lawyers. Any sector where lawyers are not picking interest, it continues to lag behind and causing social societal problems. It is us lawyers to now understand this and be able to change the tide. Thank you so much. Over to you, dear moderator.
Thank you very much. This discussion has been such a point of reflection. I'm hoping it's not just for me, but for everyone.
Hello?
Yes, can you hear me? Hello? Hello? Can I be heard? Okay. Okay. Thank you very much, Dr. David Kavanda. Your discussion has been such a point of reflection. I'm hoping it hasn't been just for me, but for everyone else on the call. But otherwise, thank you. Thank you very much. Members, please keep your questions coming in the chat room. Doctor, I had just one question for you. You have talked about, for example, the need to protect the vulnerable communities, especially in matters of food security. I'm looking at communities like Karamoja. What practical steps can a lawyer take, besides just litigation, what practical steps can a lawyer take to protect such communities? Thank you.
One of the things that we have to do is to cause the local governments, but in Karamoja right now, local governments are also not facilitated well, but to cause government, because Karamoja is not like any other place in Uganda, as we have plenty in other, regions in the country, there is always scarcity in Karamoja. So what can the government do? Simple. Just establish maybe food markets, and the government must subsidize. So the lawyers must force that to happen. We just need to do public interest kind of litigation or public interest legal intervention, because not only litigation that cause change. Why shouldn't we as lawyers engage with the Office of the Prime Minister or the Ministry of Disaster Preparedness? Just the other year, the Uganda Human Rights Commission indicated that 2,000 people in Karamoja died because of hunger. And maybe that is what they wanted us to know. Sometimes the number is bigger. So that is what I'm looking at, which we can do. Engaging local governments, engaging like particular ministries, and litigation. We sue them.
Okay, thank you very much. Do we have other questions from the comment section? We have comments coming in. Mr. Roberts says good representation. Dennis Kavuma says very informative. Mr. Andrew Aller says that's outstanding. Dennis Kavuma says, but what can one do about the bureaucracy surrounding it? I don't know.
Here as lawyers, and many times when I meet in a space like this, I speak out my heart. There is a bureaucracy surrounding all these issues, food systems, and also beyond the bureaucracy, we are dealing with trade, with food industry. It is big money. You lawyers, I have seen money. I had never seen money till when I started doing work around advocates around with the right to adequate food. Those people who are pushing dangerous synthetic agrochemicals to us, they are big money. Those people who are pushing baby foods, formulas, we are talking about serious money. And I even don't know what other lawyers are doing in other sectors, very important sectors also. But science is on our side. They also know that what they are doing is wrong. They do it intentionally. You understand? Some of these companies have budgets like 20 times bigger than our national budget. But that alone cannot save them from us, because the science evidence is on our side. How would I be standing if that wasn't the case? So to go around these bureaucracies and their money prowess, it is the law. We can use the international law, the regional law, the East African law. I didn't talk about it. It's very clear. And then also our laws. For example, the NEMA Act can also be used. But it takes many people to cause change. Because if I'm an isolated Kabanda, it reaches a time when it's, how I said that Kabanda, we are used. But if we as lawyers, we start questioning these, even from our private practice, eat in a given restaurant, because I know many of you are eating in restaurants from day one when the year starts to when the year ends. Because some of them, for example, the main restaurants in Kampala have a unique taste. They have a unique aroma. You can open the food, even if it was not labeled, and you can tell this food came from this restaurant. Do you know what happens? It is because of the spices they use, and many of these spices are synthetic. So you wake up one day, you collect your receipts and say, I have been eating in this restaurant from, you may have proof or you may not even show them. Please tell me the combination you use in this food. You'll be shocked they will not tell you. Okay, if you are not telling me the combination, tell me the ingredients. Because it is your life, dear lawyers, as you spend 100,000 of a meal in Sheraton or everywhere. It is your money. People go to Serena and they eat. And the moment they get to know that you are inquisitive, they'll change and say, now you can eat, because there are other specialized restaurants in those hotels. Now they will change you from maybe here and they take you maybe to Platinum, or like, for example, they know me. They cannot put me to the general serving area. I don't eat. Yeah, but I have realized that when they know that you care about what you eat, then they put you in some other cream of other Ugandans who are very few. So we can question and we can even sue them. I have also seen in the comments someone saying, this is Andrew, grown-up lawyers eating icing sugar. They do. They do. I'm not exaggerating, dear lawyers. You all know what you do. Or someone, they serve cake, even in their houses, and then someone eats almost a kilogram of cake. It's like, but what's up? God, what are you doing? Yet they don't know that what they've eaten is going to cause non-communicable diseases. Before they know it, they have all sorts of cardiovascular diseases. They have all, and they become weak. They become obese or overweight. Thank you so much.
Thank you, Doctor. I think the final question to you, still piggybanking on the point that has been raised by Mr. Dennis Kavuma, and your point of the institutions or the corporations that are pushing these agendas being big. My question is, we have seen, not on paper, but when you go down to investigate some of these institutions or organizations, they are coming into the country, and for example, in the name of agriculture or introducing modified seedlings or foods that we originally have in our markets, but modified versions, how do you protect our market or the population right from the point of incorporation or these institutions entering the country? How can one, as a lawyer, strategically position themselves to protect and litigate this? Thank you.
Dear colleagues, lawyers, if one wants to practice in this space, there's a lot of reading. That's number one. We need to read deeply about this science because they can challenge you. But number two, about the legal discussions that are happening at a global scale. That's where we start from now. Secondly, having armed yourself with all this literature, because it is available. There are many peer-reviewed journals, there are many, published legal and even cases. For example, I've read GMOs and the kind of discussion in the US, Canada, India, and how people have been even committing suicide, the legal outcome. Do you know that for those GMOs, if they contaminated your garden, what do I mean contamination? For example, if you have a garden of maize here and your neighbor planted GMOs, and because of open pollination, you wake up having the genes of GMO in your garden, you must pay the seed company. How unfair, So we just need to, first of all, read and understand. But number two, for me, most especially, is using a human rights-based approach. Because when you go into other paradigms, they are talking about trade. They will bring in their freedom, to trade, their freedom to contract, their free speech. All these, they bring in intellectual property, but human rights law gives us a very wide space within which we can hold these people accountable, not only the corporations, but also the government itself as a state, but also the government individuals, the technocrats who work in governments. Because in the Constitution of Uganda, Article 20, the human rights are inherent. They must be protected, respected, and upheld by government, by all agencies of government, and by all persons, including the non-natural persons like companies. So we can hold them accountable. But you need to arm yourself as a lawyer, read such that by the time, because it is not for faint-hearted, it is serious work. You are fighting very big corporations, and they are watching. They know that they can bring like huge legal, maybe law firms against you. They've done this to me. But me, I know if I've read, if I'm armed, maybe another thing as Uganda Law Society, we can work together under the food cluster to also have some conversations with the judiciary, because at the end of the day, it is them to determine some of these cases. But if they are not self-aware of what is happening in this sector, on seed, on chemicals, on the food itself, we will end up getting very bad judgments. But maybe I'll stop here.
All right. Thank you very much, Doctor. I think that was the final question. In the chat, we have, in the comment section, we have Mr. Bright Arinaitwe, that says, I agree with Doctor. The existing legal framework and practice in areas like genetically modified organisms, food and animal rights is weak. All right. Thank you very much, Mr. Bright, for your comment. And I think we have come to the end of our session, unless we have further questions from the plenary. Do we have questions? But unless otherwise, I would like to take this opportunity to thank our speakers and presenters. What we have learned today has been not just learning points, but areas of reflection. Right from the first presentation on political participation and freedom of faith-based association, academic freedom in Uganda by Mr. Mugabe, and later, just right now, the right to food as a human right. I want to thank you all for the presentations that we have had, and I want to also caution us who have been learning and listening from the presenters that let's not take what we have learned, let's not leave it here. But what we have had today are building blocks for a just and fair society. Yeah. Without further ado, I also want to thank the Uganda Law Society for organizing this session, the Radical New Bar. Thank you everyone for logging in and keeping in the session and being active throughout the session. This is from me and the Uganda Law Society. Thank you and have a lovely evening. Bye.